amongst the wild threads of history and the myriad of paths. My path saw the Imperium rise from the ashes left in the wake of the Great Revolt. Thou shalt not make a machine in the likeness of the human mind. With that commandment, new avenues of human potential were explored. Mentats, Suk Doctors, Sword Masters, and the mystical Bene Gesserit Sisterhood. But it was the Navigators and their monopoly on space travel that set the conditions for the Imperium. But I am telling you of the universe you already know. Let me describe the one you do not. In this other universe, my mother, Lady Jessica, consort to Duke Leto Atreides, gave birth to a daughter, a girl they named Ariste. Because of her obedience to the Bene Gesserit, Lady Jessica is trained as a truth-sayer. Because of that training, Lady Jessica was able to detect Dr. Yue's deception. Because of the forewarning of his betrayal, House Atreides survived the Battle of Arrakeen. Because of their survival, the Emperor declared a full-scale war of assassins. Because of the war, the Sardaukar were deployed to ensure spice shipments continued without interruption. Because of the Sardaukar, the Fremen were eradicated. There was no Muad'Dib, no Lisan al-Gaib, no Kwisatz Haderach. I see a universe where I, Paul Atreides, was never born. All my visions lead to horror, except this one. This one leads to you.
Well, I guess it's crazy that I look bald right. Oh wait, bald right there, but it's literally just the gray hairs on my head. I have to exit the game, don't I? Yes, I do. I forgot to launch my keyboard thing. Not my, excuse me, not my keyboard thing. The controller thing. All right. Controller open. Now we can launch Dune Awakening. Once Dune gets launched, we will start with our classwork.
I dream of it, amongst the wild threads of history and the myriad of paths. My path saw the Imperium rise from the ashes left in the wake of the Great Revolt. Thou shalt not make a machine in the likeness of the human mind. With that commandment, new avenues of human potential were explored. Mentats, Suk Doctors, Sword Masters, and the mystical Bene Gesserit Sisterhood. But it was the Navigators and their monopoly on space travel that set the conditions for the Imperium. But I am telling you of the universe you already know. Let me describe the one you do not. In this other universe, my mother, Lady Jessica, consort to Duke Leto Atreides, gave birth to a daughter, a girl they named Ariste.
All right, let's do it.
Religious discrimination. Chapter checklist. Become familiar with the religious implications of the First Amendment to the U.S. Constitution. Understand that employers must reasonably accommodate the religious beliefs of their employees. Appreciate that religious accommodation may not extend to situations creating an undue burden on the employer. Recognize that a bona fide occupational qualification exists for religious institutions wishing to hire members of their own faith. Realize that religious practices, for example, wearing certain hairstyles such as dreadlocks, long hair, and beards, cannot compromise food safety or seniority under collective bargaining agreements. Know that employers generally cannot tell employees where to live. Learn that employers do not have to permit employees to promote their religious beliefs at the workplace. Be aware that employers do not have to allow religious services in the workplace. Be cognizant of the fact that employers do not have to accommodate an employee beyond what the religion itself requires.
I feel like
Recognize that religious discrimination is one of the
the end.
protected classes under
Like
the
I said,
Civil
the
Rights
end.
Act. In the news, Khadija Campbell, an employee of Bare Feet Shoes in Philadelphia, was fired for wearing a religious scarf to work. She received back pay. Although reinstated, she has refused to return to work, claiming that religious toleration is supposed to be guaranteed in the United States. Campbell described herself as thick-skinned except with regard to her religious beliefs. Religious discrimination is the fastest growing category of discrimination according to the Equal Employment Opportunity Commission, EOC. Claims of this type of discrimination have risen 87% since the year 2000, which is 4 times greater than any other category. Nigel Tillman, head of the labor and employment group in the law firm Proskauer Rose's Chicago office, intimated that the number of religious discrimination suits will continue to rise. Denise Klein, an employment lawyer in the Raleigh, North Carolina, office of law firm Smith Moore Leatherwood, cautioned that granting religious accommodation could result in complaints from other employees. A portion of these will include individuals who are affronted by religious proclamations and prayers that are within earshot. Which takes precedence, an employer's dress code or an employee's religious garb? Is it a
Dress
hard
code.
and fast rule, or does the determination depend on the circumstances? Source: Courtney Rubin, Religious Discrimination Complaints on the Rise at Work, Inc., October 20th, 2010.
On
http://www.incc.com/news/articles/2010/on-the-rise.html.
On dash the
Introduction.
dash.
The First Amendment to the U.S. Constitution provides for freedom of religion. It also states that Congress shall not establish a national religion, thus ensuring the right of individuals to engage in whatever religious practices they wish. These practices must not, however, violate other laws, such as criminal
just
laws
realized I need to go
prohibiting
draw blood.
sacrificial offerings. The First Amendment applies directly to the federal government and to the states through the 14th Amendment. Although the Constitution protects individuals from governmental infringement, Title VII protects them from employment discrimination. Religious affiliation is one of the classes protected under Title VII from invidious discrimination. Employers may not refuse to hire an individual because he or she is a member of a particular religion. Employment perspective. Herman Tuffle, an atheist, is the owner of the Classics bookstore. Seamus O'Neill applies for a position in the bookstore. During the course of the interview, O'Neill mentions that one of the priests of his parish saw the Classics employment advertisement in the local paper. Herman, who never questioned O'Neill about his religion, refused to hire him. O'Neill, uncertain as to why he was not hired, relates the story to one of his friends. The friend tells him that Tuffle is a confirmed atheist. O'Neill files a claim with the EOC. Will he win? Yes, as long as O'Neill was otherwise qualified for the position and Tuffle had no justifiable reason, Tuffle will have no valid defense for refusing to hire him. What if Tuffle had hired him and then, upon learning of O'Neill's religious affiliation, terminated him? The result would be the same. Accommodating religious beliefs. Case 14.1, 14.3. To require an employer to accommodate an employee's religious beliefs, the employee must first explain to the employer what his or her religious beliefs are and how they are being compromised by the employer because of the task at hand. Reasonable accommodation of a religious belief must be made by the employer if such accommodation would not cause the employer undue hardship, compromise the rights of others, or not require more than minimal cost. If the employee resigns or is terminated for failing to perform the job because of religious beliefs, then the question of religious discrimination will be decided on the basis of the criteria of reasonable accommodation. Reasonable accommodation of a religious belief must be made by the employer if such accommodation would not cause the employer undue hardship, compromise the rights of others, or require more than minimal cost. Many claims of religious discrimination relate to religious observance. Employers have a duty to make reasonable accommodations for the employee as long as doing so does not present an undue hardship for the employer. Employment perspective. John Edwards, a Catholic, is employed as an intern at Bay Ridge Hospital. At times, Edwards must be physically present at the hospital for 36 hours. When this occurs mid-Saturday to Sunday evening, it conflicts with Edwards' religious practice of attending Massachusetts. When Edwards informs the hospital, his plea is ignored. Is the hospital guilty of religious discrimination? Yes. Bay Ridge Hospital could make a reasonable accommodation for Edwards to allow him 1 hour to attend Mass, either on Saturday evening or on Sunday. This provision does not present an undue hardship to the hospital, which could either rearrange his work hours or give him a 1-hour break. Suppose that the hospital is able to rearrange Edwards' work hours to allow him to have all Saturday evenings off. Some time ago, the Catholic Church permitted its members to attend a service after 4 p.m. on Saturdays to fulfill the Sunday obligation. Edwards insists that he must attend Mass on Sunday because that is the way he was raised. He does not accept this Saturday night exception. Has Bay Ridge Hospital made a reasonable accommodation? Yes. After John advised Bay Ridge Hospital that he was a Catholic, It worked out a schedule to permit him to attend Mass on Saturday afternoon or evening, which is acceptable to the Catholic Church. Edwards is being unreasonable in insisting that he be permitted to attend Mass on Sunday. He is asking for an exception on religious grounds that is not required by the religion itself. Employment perspective. Sydney Green, who is Jewish, responds to an advertisement for a position as a manager in a Food King store. During the interview, Green is told that the position is for weekend work. Green tells Food King that his religion does not permit him to work on Saturdays. Food King says that this is the only position open and the hours cannot be altered with the weekday manager. Green argues that the advertisement did not specify weekend work and files a religious discrimination claim with the EOC. Will he win? No. The advertisement does not have to specify every detail of the job. Green asked for an accommodation, and Food King recounted that the accommodation would impose an undue hardship on it because it would leave no managerial coverage for Saturdays. Green claims that once Food King learned he was Jewish, it told him that the position was for weekend work, knowing that he would have to decline because of his religious beliefs. If Green could prove this, he would win. But there is no evidence that Food King knew Green was Jewish when it told him that the opening was for a weekend job. Under the facts as stated, Green's claim would most likely fail. Bona fide occupational qualification. Case 14.6. Religious organizations are permitted to discriminate as long as the position relates to the promotion of the religion. Religious belief is considered a bona fide occupational qualification, BFOQ. Religious belief is considered a bona fide occupational qualification, BFOQ. Employment perspective. St. John's Lutheran Church has a position available as an administrative assistant to the minister. Mary Beth Luciano, a Catholic, is refused the position because she is not Lutheran. Is this religious discrimination? No. St. John's Lutheran may discriminate in favor of its own parishioners because the position is involved with the operation of the church. Employment perspective. Mount Franklin United Methodist Church runs a summer soccer camp for children ages 6 through 12. The camp is open to children of all faiths. Al Kaplan, who is Jewish, applies for the position of soccer instructor. Al played 4 years as starting forward for the State University, and he is well qualified. Mount Franklin refuses to hire Kaplan because he is not Methodist. Kaplan claims that religious beliefs are not a BFOQ for a soccer instructor. Who would win? Kaplan. The determination would hinge upon whether Mount Franklin is trying to promote the Methodist religion to young children through their participation in the soccer camp. Because the camp is open to children of all faiths, this is not the case. Case 14.2, 14.4. Religion incorporates both religious practice as well as religious belief. There is often a conflict as to whether a group qualifies as a religion or is secular in nature. One test to apply would be to determine whether a group's members belong to an organized religion in addition to that particular group. Religion incorporates both religious practice as well as religious belief. Employment perspective. During an interview for a supervisory position in the auto plant of Prestige Motors, Tom Westfield, the applicant, was asked whether he could start to work the evening shift every Tuesday night. Westfield responded that he was obligated on Tuesday nights to attend a Ku Klux Klan meeting, but that he would be available every other evening. Westfield was rejected because he was unavailable on Tuesday nights. Westfield filed a claim with the EOC under Title VII, claiming that Prestige would not make a reasonable accommodation for his religious practices. Prestige argued
Klan's
the Ku
not
Klux
a-
Klan is not a religious organization.
Yeah.
Will Westfield win? No.
No.
The Ku Klux Klan has been determined to be a political rather than a religious organization, and as such no accommodation has to be made for participation in its activities. Workplace Religious Freedom Act of 2012. Case 14.5. The Workplace Religious Freedom Act is currently before Congress. This act was first proposed in 2005 as an amendment to the Civil Rights Act. Recently, it has garnered the support of the American Civil Liberties Union. Religious practices that require a religion's members to wear certain clothing or to groom themselves in certain ways are protected under the act unless they present an undue hardship to the employer. New York City passed a version of the act in 2011. Employment perspective. Morris Gold was hired as a teller for Mid-Island Savings Bank. He wore his yarmulke for work the first day and was told to remove it because it was not proper attire. Because he refused,
I don't know what a yarmulke
Gold
is.
filed a claim with the EOC, stating that he was following was a recognized religious practice of the Jewish faith. Will he win? Yes. The practice of wearing a yarmulke is protected because it does not present an undue hardship to the employer. Ethical issue. The case of a true believer. Christine Wilson was an information specialist for US West, a telecommunications company. US West had no dress code. Wilson made a religious vow to wear an anti-abortion button depicting a fetus. It was 2 inches in diameter. The button caused disruption at work. Wilson's supervisors informed her that she could cover the button or wear it in her own office. Wilson refused. She was sent home and subsequently fired for missing 3 days of work without a legitimate excuse. Wilson argued that her free speech was violated. US West countered that an employer may restrict free speech in the workplace. Wilson complained that she was the victim of religious discrimination. US West rebuffed her argument, stating that this vow was Wilson's own creation. The vow was not a requirement of Catholicism. In addition, US West commented that the button had political overtones that it did not want to promote in the workplace. Wilson v. US West Communications, 58F.3D 1337, 8th Circle 1995. Questions. Were Wilson's actions ethical? To what extent is there free speech in employment? Should Wilson's button be covered under the First Amendment? Are US West's actions ethical with respect to religion? Ethically, where should an employer draw the line with respect to accommodating religious beliefs? Employment perspective. Mustafa Derry, a Rastafarian, wore his hair in dreadlocks. When he was hired by Faster Food Service, he was told he would have to cut them. He refused. Derry filed a claim with the EOC, citing that the wearing of dreadlocks was part of his religion. Faster Food maintained it was unsanitary and in violation of health department regulations. Will Derry prevail? It may be possible to accommodate Derry by having him enclose his hair in a plastic cap. If Derry refuses, then his religious practice will be overridden for public health reasons. First Amendment protection. The First Amendment to the U.S. Constitution addresses religion in two respects. First, it prohibits the government from establishing a national religion. Freedom from religious persecution is an important reason why many immigrants came to this country. Permitting people the freedom to choose how,
I have no idea
when,
what I need to do
and
to build
where
my
worship is an
my
important consideration in this country. Allowing
ornithopter.
others to discriminate because of religion not only compromises this First Amendment right, it also promotes the economic advantages of belonging to one religion. The latter factor violates the Establishment Clause. The First Amendment also promotes the freedom to associate. If a person chooses to associate socially only with members of his or her own religion, that is a protected choice. Employment, however, is not social, it is economic. It is unfair for an employer to choose its employees on the basis of their religious preference. How is this preference job-related? It is not. Employers should respect the right of employees to worship as they please on their own time and, if possible, should reasonably accommodate their employees to enable them to do so. Religious harassment. Every protected class has a subset for harassment, and religion is no different. Religious harassment of every religious minority has always existed. Jews, Catholics, Buddhists, Hindus, and Muslims, among others, have all experienced it. Since 9/11, religious harassment has been more pronounced against Muslims and other religions of Arab and Asian countries. Name-calling, jokes, and pictorials demeaning an employee's religion are all forms of religious harassment that employers have to guard against.
Case 14.1 Miguel Sánchez Rodríguez V.
AT&T Mobility Puerto Rico Incorporated. 2012.
Wow,
WhatsApp,
that was
Lexus
a
4911,
okay.
First Circuit. The issue is whether an accommodation should be made to permit the employee to attend services on the Sabbath. Toruela, Circuit Judge. Plaintiff appellant Miguel Sanchez Rodriguez, Sanchez, appeals the district court's award of summary judgment to his employer, AT&T Mobility Puerto Rico Incorporated, AT&T, on his claims of religious discrimination and retaliation under Title VII of the Civil Rights Act, Title VII. Although we disagree with some aspects of the district court's decision, we conclude that the grant of summary judgment for AT&T was correct. Sanchez was hired by AT&T in March of 2000 as an installation technician. In February of 2001, Sanchez transferred to a retail sales consultant position in the Caguas Calle Maco Fajardo sales region, Caguas region, where he sold cellular telephones and accessories at service kiosks located in shopping centers. His yearly salary between 2003 and 2006 ranged from $23,129.59 to $26,425.47. Sanchez also earned yearly commissions ranging from $10,653.03 to $18,938.17. In September of 2006, Sanchez informed his supervisors and AT&T's Human Resources, HR, department that he had become a Seventh-day Adventist. As a
Hey,
Seventh-day
that's me.
Adventist, Sanchez had a religious obligation to abstain from work on Saturdays and attend Sabbath services. Therefore, he requested an accommodation in his work schedule by being allowed to take Saturdays off. In October of 2006, Sanchez presented a letter from his church confirming and explaining his religious observance of the Sabbath. On approximately November 21st, 2006, AT&T's HR department sent Sanchez a letter stating that his position necessitated that he work on rotating Saturday shifts and that it would be a hardship on AT&T to grant Sanchez his requested accommodation. In lieu of a change in his schedule, AT&T offered Sanchez two different positions that would not require him to work on Saturdays, Representative 1 for Customer Service, Rep 1, and Business Sales Specialist. The Rep 1 position typically required Saturday hours, but AT&T determined that it would not be a hardship to allow Sanchez to take Saturdays off. The Business Sales Specialist position did not require work on Saturdays or Sundays. The annual wages for the Rep 1 and Business Sales Specialist positions were $23,088 and $22,970, respectively. However, neither position offered the opportunity to earn commissions. Thus, Sanchez declined both offers, since his income would significantly decrease. In early 2007, Sanchez applied for two other positions at AT&T in Puerto Rico, but was not interviewed for either position. In February of 2007, Sanchez presented another letter from his church confirming his observance of the Sabbath. Sanchez also filed a charge with the Equal Employment Opportunity Commission, EOC office in San Juan, Puerto Rico, alleging religious discrimination. In March of 2007, Sanchez informed his supervisor that he had been trying to find coworkers who were willing to swap shifts with him and take his Saturday shifts, but that he was unable to do so. Sanchez stated that he was therefore forced to violate AT&T's attendance policy by not working his Saturday shifts. Sanchez's supervisor told him that working Saturdays was a requirement of his job. Sanchez's supervisor also notified AT&T's HR department about the situation. On approximately April 5, 2007, AT&T's director of HR sent Sanchez a letter. The letter described working rotating shifts, including Saturdays, as an essential function of Sanchez's position. The letter acknowledged that Sanchez had declined the two positions offered by AT&T because of the reduction in salary those positions would entail. The letter noted that Sanchez had continued to miss work on Saturdays, but that no adverse disciplinary action had been taken for these absences. However, it warned Sanchez that letting him miss work on Saturdays was not an option for it undermined the scheduling/attendance requirements. Therefore, the letter said that AT&T would start disciplining Sanchez for any additional Saturdays he missed. The letter then stated, "It is important for the company to maintain a neutral scheduling system and not to burden other employees into working more than their share of Saturdays, among others. In an effort to accommodate your necessities, we are going to allow shift swaps with your coworkers. Be mindful that the company cannot impose a shift swap on the employees. It would be in a voluntary fashion. We shall try this alternative for a period of 2 months to determine whether it is workable or not. You will need to be active in obtaining voluntaries. The company will assist you in providing the employees' schedules, allowing you to advertise your need for swaps on the bulletin board and in any other form that you deem necessary and is acceptable. After the conclusion of the 2 months trial period, we shall meet to discuss the outcome and whether it gave us the needed results or whether other measures are needed to accommodate your needs." There is no evidence in the parties' stipulation or anywhere in the record that AT&T ever actually gave Sanchez the employees' schedules. In May of 2007, Sanchez informed the HR department that he could not find workers to swap shifts with him and that he would therefore be absent on Saturdays. In response, that same month, Sanchez's supervisor placed him on active disciplinary status. The supervisor also warned Sanchez that further measures, including termination, would be taken if he continued to miss work on Saturdays. In the same month, Sanchez's supervisor also sent him 8 emails advising him that his sales figures were below expectations. In June of 2007, Sanchez applied for a retail sales consultant position in Worcester, Massachusetts. Sanchez's application was rejected on the ground that he did not meet basic qualifications for the position, even though it was the same position he held in Puerto Rico. That same month, the HR department emailed Sanchez, again informing him that his absences would be subject to the attendance policy. Sanchez was asked to meet with HR to discuss his absenteeism, although the record does not indicate whether this meeting took place. Finally, on June 20th, 2007, Sanchez tendered his letter of resignation, stating, "An opportunity had showed up which I can have the Saturday winky face. In addition, it represents an opportunity for my professional growth." On Sanchez's Title VII religious discrimination claim, the court held that even though Sanchez had demonstrated a prima facie case of discrimination, AT&T had shown either 1. That it offered Sanchez a reasonable accommodation, or alternatively, 2. That accommodating Sanchez would have placed an undue burden on AT&T. As stated by the district court, to establish a prima facie case of religious discrimination, the employee must show that 1. A bona fide religious practice conflicts with an employment requirement, 2. That he or she brought the practice to the employer's attention, and 3. That the religious practice was the basis for an adverse employment decision. There was no dispute that Sanchez satisfied the first and second prongs, but AT&T argued that it took no adverse employment action against Sanchez. The district court held that Sanchez satisfied the third prong because the disciplinary actions that AT&T took against him starting in May of 2007 were adverse employment actions. Once an employee has made out a prima facie case of discrimination, the employer must show that it offered a reasonable accommodation or that a reasonable accommodation would be an undue burden. The district court held that the alternate positions that AT&T had offered to Sanchez were not reasonable accommodations because those positions offered a steep decrease in earnings. However, the court held that allowing Sanchez to arrange voluntary shift swaps with other employees was a reasonable accommodation. Furthermore, assuming arguendo that none of AT&T's proposed accommodations were reasonable, the court held that AT&T had shown that allowing Sanchez to take Saturdays off would have created an undue hardship for AT&T.
I got really lucky. My place let me have Saturday off.
Saturday was a high-activity day for AT&T, and that the company relied on a neutral scheduling system to avoid burdening employees with a disproportionate number of Saturday shifts. The court therefore dismissed the discrimination claim. On the retaliation claim, the district court held that Sanchez had made out a prima facie case of retaliation under Title VII, but that AT&T had successfully rebutted that case. To establish a prima facie case of retaliation, an employee must show that 1. He engaged in protected conduct under Title VII. 2. He he experienced an adverse employment action. And 3. A causal connection exists between the protected conduct and the adverse employment action. The court held that because of the temporal proximity between Sanchez's EOC complaint and various subsequent adverse employment actions, rejecting Sanchez's applications for other positions and disciplining him for absenteeism, Sanchez had satisfied his initial burden. This shifted the burden to AT&T to show that it had a non-discriminatory reason for its adverse employment actions. However, the court found that AT&T had demonstrated non-discriminatory reasons
I just need
for its
aluminum
actions
ingots
and
now.
thus dismissed the retaliation claim. The district court found that Sanchez had established his prima facie case, and AT&T concedes this point for purposes of argument on appeal. Thus, we consider whether the facts, viewed in the light most favorable to Sanchez, demonstrate either that AT&T offered a reasonable accommodation or that accommodating Sanchez would have resulted in undue hardship. We believe that this totality of the circumstances approach is sensible. Thus, to determine whether AT&T offered Sanchez a reasonable accommodation, we will analyze whether the combination of accommodations offered by AT&T was reasonable. AT&T points to 3 ways in which it tried to accommodate Sanchez. 1. By offering him the Rep 1 and Business Sales Specialist positions as a substitute for his Retail Sales Consultant position. 2. By allowing him to swap shifts with his coworkers. And 3. By refraining from disciplining him for absenteeism prior to May of 2007. Sanchez contends that AT&T's offer of other positions was not reasonable because those positions offered lower compensation. He also contends that the offer of shift swapping was not reasonable because AT&T did not provide the schedules of other employees, as it had promised. Taken together, we believe that the efforts made by AT&T constituted a reasonable accommodation of Sanchez's religious beliefs. Therefore, we affirm the judgment of the district court on the discrimination claim. We need not reach the question of whether accommodating Sanchez would have been an undue hardship for AT&T. Sanchez claims that AT&T retaliated against him for filing his EOC complaint in February of 2007. The district court held that Sanchez established a prima
Oh my
facie case.
god, it was behind
However,
me.
the court then held that AT&T had demonstrated non-discriminatory reasons for its adverse employment actions, and that Sanchez had failed to show that these reasons were pretextual. On appeal, Sanchez argues that the district court incorrectly concluded that Sanchez had not shown that AT&T's reasons were pretextual. Sanchez easily satisfies the first prong of the prima facie case, since he engaged in protected activity by filing a charge with the EOC. Sanchez points to 3 different adverse actions that he claims are causally connected to his protected activity. 1. AT&T's failure to interview him for the small biz advisor position. 2. AT&T's offer of unreasonable accommodations. And 3. Disciplinary actions for absenteeism. We explore in turn whether these actions constitute retaliation. The parties stipulated that Sanchez applied for the small business advisor position on March 1st, 2007, but that he was not scheduled for interview for this position. There is no evidence in the record regarding why Sanchez was not interviewed. A failure to hire can be an adverse employment action for the purposes of a Title VII retaliation claim. Here, the record is entirely devoid of any information regarding whether Sanchez was qualified for the small biz advisor position or whether there was even an opening for such a position. Because Sanchez is the party who bears the burden of demonstrating these factors, this lack of evidence weighs against Sanchez, even though AT&T was the summary judgment movement. Thus, we conclude that Sanchez cannot demonstrate that the failure to interview him for the small biz advisor position was an adverse employment action for the purposes of his retaliation claim. Next, Sanchez argues that the accommodations offered by AT&T, the alternate positions, not imposing discipline for failure to show up for work on Saturdays up to May of 2007, and the shift swapping, were so unreasonable that the mere offer of them constituted an adverse employment action. We disagree. An adverse employment action in the retaliation context is any action that might have dissuaded a reasonable worker from making or supporting a charge of discrimination. Hypothetically, an employer could offer an accommodation that is so objectively unreasonable or unworkable, or such an insult to an employee's religious beliefs that a reasonable worker would be dissuaded from pursuing a charge of discrimination. But that is not the case here. As discussed above, the accommodations offered by AT&T were reasonable. Finally, Sanchez argues that AT&T retaliated
I can't believe
against
there's
him
a
by disciplining him
spice
for his
bloom right there.
absenteeism. The stipulation reflects that AT&T, 1. Placed Sanchez on active disciplinary status, 2. Sent him emails advising him that his sales quotas were below expectations, and 3. Warned him that his absences would be subject to the company's attendance policy. Whether an admonishment constitutes an adverse employment action may depend on a number of factors, including in particular its practical consequences. But, as the issue does not affect the ultimate disposition here, we can bypass the issue and assume arguendo that in this case Sanchez suffered an adverse employment action. We also find that Sanchez has satisfied the causal connection prong of his prima facie case. Very close, temporal proximity between protected activity and an adverse employment action can satisfy a plaintiff's burden of showing causal connection. Here, Sanchez filed his EOC complaint in February of 2007 and was disciplined in May of 2007. We believe this proximity is close enough to suggest causation, especially given the inferences we must draw in Sanchez's favor. Because Sanchez has made a prima facie case of retaliation based on the discipline he received in May of 2007, the burden shifts to AT&T to show that it had a non-discriminatory reason for disciplining him. We find that AT&T easily satisfies this burden. Sanchez admits he was absent from work on Saturdays, and in turn AT&T disciplined him for his absenteeism. The burden thus shifts back to Sanchez to show that AT&T's reasons were merely pretextual. Here, Sanchez's claim founders. To defeat summary judgment in a retaliation case, a plaintiff must point to some evidence of retaliation by a pertinent decision-maker. Here, Sanchez points to no evidence whatsoever, and as noted previously, made no effort to discover any such evidence. Since Sanchez has failed to point to any evidence that AT&T's reasons for disciplining him were merely a pretext for religious discrimination, we affirm the District Court's grant of summary judgment to AT&T on the retaliation claim. The District Court's grant of summary judgment to AT&T on Sanchez's Title VII religious discrimination claim is affirmed. The District Court's grant of summary judgment to AT&T on Sanchez's Title VII retaliation claim is affirmed. Judgment for AT&T. Case commentary. The First Circuit decided that it would be an undue hardship to rearrange work schedules to accommodate Sanchez's religious belief. Case questions. Are you in agreement with the decision of the court? Was AT&T justified in disciplining Sanchez for absenteeism? Is there an ethical resolution to this case? James Patterson and Lisa M. Coffee versus Indiana newspapers.
I got really lucky that my job just gave it to me. I think I only wound up working like one Saturday in the entire time I was going to church.
The Indianapolis Star discriminated against 2 of its employees due to their religious beliefs. Sykes, Circuit Judge. Lisa Coffey and James Patterson are former editorial writers at the Indianapolis Star who left the newspaper in 2003 and 2005, respectively. They departed under very different circumstances, but both claim they were victims of employment discrimination on the basis of their religion. More specifically, discrimination because they are Christians who believe that homosexual conduct is sinful. The District Court entered summary judgment for the Star on all claims, and Coffey and Patterson appealed. We affirm. The Indianapolis Star is Indiana's largest newspaper and was acquired in 2000 by media giant Gannett. Barbara Henry serves as the Star's president and publisher, which puts her in charge of directing the newspaper's overall operation. In 2003, the Star named Dennis Ryerson as editor and vice president. In that capacity, he is responsible for newsroom staffing and the content of news articles and editorials. Andrea Neal served as the Star's editorial page editor until the summer of 2003.
I should have stored my vehicle.
When she left the newspaper to become a teacher. She was replaced by Tim Swarens. The editorial page editor reports to the editor and directs the content of the newspaper's editorials and the columns on its opinion pages. Generally speaking, opinion columns represent the viewpoint of the author. Editorials are assigned and represent the editorial position of the newspaper. Coffey joined the Star in 1999. In the beginning, she spent 3 days a week working as a copy editor and 2 days a week performing administrative duties for a journalism intern program. Although she enjoyed working on the Metro desk, she made no secret that she wanted to move to the editorial department. Her efforts paid off in 2002 when the Star exchanged her copy editor responsibilities for an editorial writer position. As an editorial writer, Coffey reported to the editorial page editor and was responsible for writing editorials and columns for the Star's opinion page. She still spent 2 days a week administering the Star's intern program, however. Coffey describes herself as a traditional Christian who believes homosexual conduct is sinful. In July 2003, in response to the Supreme Court's decision in Lawrence
that's because she's an idiot.
539 U.S. 558, 123S, CT 2472, 156L, ed. 2D 508, 2003, Coffey wrote an opinion column describing the HIV risks associated with sodomy. Neal approved the article, but Ryerson decided it was unsuitable for publication because it provided a too graphic description of anal intercourse. He told Neal, however, that he was open to publishing a less graphic column on the risks of unprotected sex. The day after Ryerson rejected Coffey's column, a member of the Christian Student Foundation emailed Ryerson expressing his opinion against same-sex marriage. Ryerson sent a responsive email asking if the Star could consider the student's letter for publication. Ryerson copied Coffey on this reply. The electronic correspondence between Ryerson and the student, by all accounts unrelated to Ryerson's refusal to publish Coffey's column, triggered an email exchange between Coffey and Ryerson about the relationship between objective truth and opinion. Coffey emailed Ryerson stating that she knew both were seeking truth, even though they held certain beliefs that are 180 degrees apart. She apologized for being angry with Ryerson, presumably over the rejected column. And
God, there's so much oil I gotta put in this.
Ryerson wrote back thanking Coffey, offering to discuss the issue over lunch, and explaining that he did not necessarily believe there is one truth, and that editorials express opinion and not truth. About an hour later, Coffey replied with a lengthy email describing her religious views. She explained that she had been knocked out by the Holy Spirit, and said that if Ryerson's perspective was correct, he should call the nut farm now to haul her away. Ryerson perceived Coffey's email as an attempt at workplace proselytization in violation of company policy. Concerned that Coffey might have sent similar emails to other employees of the newspaper, Ryerson wrote back telling Coffey that it was inappropriate to proselytize at work. Before and after these events, management at the Star became aware that Coffey had developed a habit of violating the newspaper's overtime policy. Coffey disregarded this warning and continued to work overtime without seeking prior approval. In the meantime, in September 2003, Ryerson decided to adjust Coffey's role at the Star. Because the aspiring journalists in the newspaper's internship program had more regular contact with newsroom reporting staff than with editorial writers, Ryerson believed the administrative oversight for the program should be shifted from the editorial department to the newsroom. This reorganization left Coffey with only 3 days of work per week as an editorial writer. Ryerson offered Coffey a full-time job back on the copy desk. In addition to providing her with a full-time position, the copy desk job would permit the newspaper to more closely supervise Coffey's work to ensure she did not violate the company's overtime policy. Coffey preferred editorial writing and asked if she could divide her week by working 3 days as an editorial writer and 2 days as a copy editor. Ryerson rejected this request as a matter of policy. He believed the news and editorial operations at the newspaper needed to remain separate. Rather than take the full-time copy desk job, Coffey resigned.
I can't believe I have
On
to
her
do
last
so
day
much
at the
work.
Star in October 2003, Coffey sent an email to Henry thanking her for the privilege of working here at the Star. I have enjoyed and appreciated it more than I can say. Patterson joined the Star as an editorial writer in 1995. He is African American and, like Coffey, describes himself as a traditional Christian who considers homosexual conduct to be sinful. Before Ryerson became the Star's editor in 2003, Patterson had a mixed employment history at the newspaper. Although he received various awards and had generally acceptable performance reviews, there were recurring problems with his writing. Patterson required more editing than any other editorial writer on the Star's staff, and his work also suffered from research and organizational problems. The newspaper hired a writing consultant to review Patterson's editorials and columns. The consultant confirmed the deficiencies in Patterson's work. In 2003, after the start of the Iraq War, Patterson submitted an editorial asking the newspaper's readers to pray for American troops. Neil revised the editorial slightly and added a prayer at the end, and the editorial ran in the newspaper on March 20th, 2003.
I can never
Publication,
imagine
however,
doing that.
Ryerson, who had just joined the Star, told Neil that he was uncomfortable with an editorial telling readers to engage in religious practices. Patterson claims that after this point, if he submitted any religious-based opinion pieces that differed from Ryerson's viewpoint, the articles would not be published, although he does not say how often this occurred. Swarens replaced Neil as editorial page editor in August 2003, becoming Patterson's immediate supervisor. He immediately noted the frequent and substantial problems with Patterson's writing. First, Patterson's pieces required more editing than any other editorial writers. Swarens also noticed regular errors in Patterson's work, ranging from misspellings to more serious reporting mistakes. For example, Patterson wrote an editorial endorsing City-County Council candidate Vernon Smith, but the candidate's name was Vernon Brown. He wrote an editorial recalling President John F. Kennedy's assassination 30 years earlier, but the assassination was 40 years earlier. He wrote an editorial in February 2004 stating that Governor O'Bannon had accepted the resignation of the State Commissioner of Motor Vehicles. In fact, Governor O'Bannon had died 5 months earlier, and the commissioner in question had not resigned. While many of Patterson's mistakes were caught in the editing process, some made it into the newspaper, and the Star had to print corrections. For example, on May 21st, 2004, the Star published an editorial Patterson had written criticizing the sufficiency of the Indianapolis Humane Society's financial disclosures. In fact, the Humane Society's annual report contained extensive and detailed information about the society's financial status, and the Star had to print a retraction. When confronted about the problems with his work, Patterson generally refused to take responsibility for his mistakes. He minimized their significance or claimed that the errors were caused by the pressures of additional work Swarens had assigned to him. Based on these errors, in December 2004, the Star escalated Patterson to final written warning status.
Maybe I can
Patterson's
steal some
performance
from
remained
Araya.
poor, however, he continued to submit editorials with misspelled names and incorrect dates. In light of these continuing errors and based on Swarens' recommendation, on May 3, 2005, the Star fired Patterson. At the time of his termination, Patterson was 51 years old. Coffey and Patterson sued Indiana Newspapers Incorporated, the publisher of the Star, alleging various forms of discrimination. Both brought claims alleging religious discrimination in violation of Title VII of the Civil Rights Act of 1964. Although Coffey and Patterson left the Star nearly 18 months apart and under very different circumstances, their religious discrimination claims overlap. Both plaintiffs contend that the Star engaged in systematic discrimination against traditional Christians who hold the religious belief that homosexual conduct is sinful. More specifically, Coffey and Patterson maintain that the Star's top editors, in particular Ryerson, opposed public or workplace expressions of religion and discriminated against those who were opposed to homosexual conduct as a matter of their religion. The plaintiffs claim that after Ryerson became editor, the Star published hordes of news articles designed to portray homosexuality in a positive light, softened its editorial opposition to same-sex marriage, promoted employees who were homosexuals or homosexual sympathizers, sought to purge the news and editorial operations of the paper of traditional Christians, and otherwise exhibited animus toward Christians who opposed homosexual conduct. Unsurprisingly, the Star disagrees. The newspaper notes that its top managers are Christians,
unsurprisingly,
and Star employees, including at least 3 members of the editorial department where Coffey and Patterson worked, share the plaintiffs' religiously motivated opposition to homosexual conduct. The Star points out that it has consistently editorialized against same-sex marriage and also has opposed the ACLU's attempt to ban Christian prayers in state legislative sessions. The Star draws our attention to its front-page nameplate, which prominently features a Bible verse. Finally, the Star says that its supposedly favorable
portrayal of homosexuality.
where are we at?
Managers are Christians.
Give us a second.
including at least 3 members of the editorial department where Coffey and Patterson worked, share the plaintiffs' religiously motivated opposition to homosexual conduct. The Star points out that it has consistently editorialized against same-sex marriage and also has opposed the ACLU's attempt to ban Christian prayers in state legislative sessions. The Star draws our attention to its front-page nameplate, which prominently features a Bible verse. Finally, the Star says that its supposedly favorable portrayal of homosexuality in its news columns amounts to nothing more than coverage of topics that are of increasing public interest. Under this framework, Coffey and Patterson must make a prima facie case of discrimination by showing that they 1. Belong to a protected class, 2. Performed their job according to the Star's legitimate performance expectations, 3. Suffered an adverse employment action, and 4. Were treated less favorably compared to similarly situated employees outside of the protected class. As we have noted, Coffey characterizes herself as a traditional Christian who believes homosexuality is sinful. She claims it was this particular religious belief, not her Christianity in general, that triggered the Star's disparate treatment of her. We have previously held that a plaintiff may proceed on a claim that her supervisors, though also Christian, did not like her brand of Christianity because T. Key issue is whether the plaintiff's specific religious beliefs were a ground for an adverse employment action. Grossman versus S. Shore Pub SCH. DIST 507F.3D 1097, 1098, 7th Circle 2007. Accordingly, Coffey has established the first element of her prima facie case. She has also established the third element. We accept that her transfer from editorial writing back to copy editing qualifies as an adverse employment action. We have said that a dramatic downward shift in skill level required to perform job responsibilities can rise to the level of an adverse employment action. The Star suggests that because the transfer would not have reduced her salary or benefits, Coffey suffered no adverse employment action. But editorial writing is more important than copy editing in the hierarchy of a newspaper, so Coffey's transfer was plainly a demotion even if the salary and benefits were the same. Coffey runs into trouble, however, on the second and fourth elements of her prima facie case. She cannot show that she met the Star's legitimate performance expectations, or that a similarly situated employee who did not share her religious beliefs was treated more favorably. The evidence is undisputed that Coffey repeatedly violated the newspaper's overtime policy, and the Star's decision to transfer her from editorial writing to copy editing was based in part on the newspaper's desire to monitor her more closely. Coffey argues at length that Ryerson transferred her because he objected to her religious perspective on homosexuality, not because she violated the company's overtime policy. This is essentially a pretext argument, and most of it is premised upon factual assertions that we, like the district court, have disregarded because of the plaintiff's violation of the local rules and submission of affidavits that contradict their deposition testimony. To the extent, however, that Coffey is claiming that Ryerson would have permitted someone who did not share her religious views to remain in the editorial department notwithstanding repeated violations of company rules. The argument is folded into the fourth element of her prima facie case. Coffey's claim founders there as well. Even assuming that Coffee was meeting the star's legitimate performance expectations, she has failed to establish that the star treated any similarly situated employees more favorably. We have said in this context that similarly situated employees must be directly comparable to the plaintiff in all material respects, which includes showing that coworkers engaged in comparable rule or policy violations. This means that Coffee must identify a comparison employee who held the same job, editorial writer, engaged in the same or comparable misconduct, repeated violations of overtime policy, did not hold her religious beliefs, that homosexual conduct is sinful, and was treated more favorably. Coffee identifies 3 employees, Swarens, Beth Murphy, and Jane Lichtenberg, that she claims were similarly situated, but treated more favorably. We note first that Swarens was Coffee's supervisor, and so cannot be used for comparison purposes. We have previously held that, ordinarily, it will not be the case that a plaintiff is similarly situated to another employee when the plaintiff is subordinate to that employee, and Coffee has given us no reason to believe this is an extraordinary case. Although Lichtenberg and Murphy, like Coffee, worked under Swarens in the editorial department, they were copy editors, which Coffee vigorously argues, and we have accepted, is significantly different from the position of editorial writer. But most importantly, there is absolutely nothing in the record to suggest that any of these employees violated the star's overtime policy at all, much less repeatedly. Accordingly, Coffee has failed to establish her prima facie case. Patterson claims his dismissal from the Star was motivated by discrimination based on his religion, race, and age. Like Coffee, Patterson has established the first and third elements of his prima facie case. He is a member of 3 protected classes for purposes of these claims. He is African American. He was 51 years old when fired, and he describes himself as a traditional Christian who is opposed to homosexual conduct as a matter of his religious belief. And Patterson suffered an adverse employment action when the Star fired him. The basic problem with all of Patterson's discrimination claims is that he cannot show he was meeting the Star's legitimate performance expectations. The undisputed evidence establishes that Patterson had a long history of performance problems ranging from reporting errors to writing deficiencies. Patterson's poor performance continued after the Star placed him on a performance improvement plan. We need not belabor this point. It goes without saying that factual accuracy, adequate reporting, and clean writing are legitimate performance expectations at a newspaper. Patterson claims that Swarens worked him harder than the other editorial writers, and that other writers made more errors than he did, but there is no evidentiary support for these contentions. Because the undisputed evidence establishes that Patterson was not meeting the Star's legitimate performance expectations, he cannot establish a prima facie case of retaliation. Patterson's Title VII claims were properly dismissed. Affirmed. Case commentary. The Seventh Circuit ruled that Patterson's poor performance was the reason he was terminated. Although Coffee resigned, she had violated her employer's overtime policy. Their religious beliefs were not a factor. Case questions. Are you in agreement with the court's decision? Do you believe the reporters should be permitted to voice their religious objection to homosexuality in their news reports?
No.
Was the Star's complaint of Coffee's overtime abuse just a pretext to terminate her because of her religious objection to homosexuality? George Daniels versus City of Arlington, Texas. 246F.3 D500, 5th Circle, 2001. Case 14.3. The issue is whether an employer should accommodate an employee's request to wear a religious pin. Wiener, Circuit Judge. Daniels was an Arlington police officer for 13 years. While working in a plainclothes position, he began wearing on his shirt a small, gold cross pin, the pin as a symbol of his evangelical Christianity. He continued to wear the pin after he was reassigned to a uniformed position, which brought him into conflict with Arlington Police Department General Order Number 205.02, C2C, the no pins policy. The General Order, as revised in November 1997, states that no button, badge, medal, or similar symbol or item not listed in this general order will be worn on the uniform shirt unless approved by the police chief in writing on an individual basis. Daniels requested in writing that then Police Chief David Kunkel make an exception to the policy and allow him to continue wearing the pin on his uniform. Kunkel declined, writing to Daniels that I have not authorized any non-department related pins and I do not intend to do so. Daniels refused Kunkel's order to remove the pin from his uniform shirt and did not respond to the police chief's offer of accommodations, which included 1. Wearing a cross ring or bracelet instead of
Wait, this is at risk?
Wearing a pin under his uniform shirt or collar, or 3. Transferring to a non-uniform position where he could continue to wear the pin on his shirt. Daniels declined these alternatives and ultimately was fired for insubordination. Daniels sued, claiming that the no-pins policy is unconstitutional on its face and that he had been the victim of intentional religious discrimination. The district court rejected Daniels' claims. Daniels asserts that Arlington Police Department General Order Number 205.02, C2C, one of many provisions regulating uniform standards for Arlington Police, is an invalid prior restraint of speech protected by the First Amendment. He contends that the order is overbroad, impermissibly giving the police chief
How is this not
to determine what expression may be displayed on an officer's uniform. This argument is unavailing. As the district court correctly noted, a police officer's uniform is not a forum for
I'm
fostering public discourse or
so
expressing
pissed
one's
off right
personal
now.
beliefs. The Supreme Court has upheld appropriate restrictions on the First Amendment rights of government employees, specifically including both military and police uniform standards. We have used 2 tests to determine whether speech relates to a legitimate public concern. Daniels fails both. The first, the citizen-employee test, turns on whether a public employee speaks not as a citizen upon matters of public concern, but instead as an employee upon matters only of personal interest. The second evaluates the content, form, and context of a given statement. None of these factors favors Daniels' argument. The content of his speech, symbolic conveyance of his religious beliefs, is intensely personal in nature. Its form melds with the authority symbolized by the police uniform, running the risk that the city may appear to endorse Daniels' religious message. The final factor, context, perhaps weighs most heavily against Daniels. Although the First Amendment protects an individual's right, for example, to shout, fire, while riding a surfboard on the Pacific swells, it offers no such protection to the same speech uttered in a crowded theater. Visibly wearing a cross pin, religious speech that receives great protection in civilian life takes on an entirely different cast when viewed in the context of a police uniform. Because Daniels' communication of his personal religious views through the pin is not speech addressing a legitimate public concern, the departmental policy does not offend the First Amendment. As recognized in FLRA, Federal Labor Relations Authority, the city through its police chief has the right to promote a disciplined, identifiable, and impartial police force by maintaining its police uniform as a symbol of neutral government authority, free from expressions of personal bent or bias. The city's interest in conveying neutral authority through that uniform far outweighs an officer's interest in wearing any non-department related symbol on it. Daniels' facial challenge to the no-pins policy fails. Having reviewed de novo the legal claims Daniels asserts on appeal, we affirm the district court's decision to dismiss his case with prejudice on summary judgment. The no-pins policy serves a legitimate governmental purpose in the context of uniformed law enforcement personnel, and Daniels undoubtedly has myriad alternative ways to manifest this tenet of his religion. Conclusion. A police department does not violate the First Amendment when it bars officers from adorning their uniforms with individually chosen adornments, even when those decorations include symbols with religious significance. Therefore, the decision of the district court is affirmed for the city of Arlington. Case commentary. The Fifth Circuit Court held that in setting a dress code, an employer may prohibit visible religious pins. Case questions. Do you agree with the court's decision? How can the freedoms of religion and speech be balanced against an employer's dress code? Why do some people insist on visibly wearing religious symbols paraphernalia, and why do some people find this practice intolerable? Kimberly M. Clowder vs. Costco. 390F.3D 126. First Circle 2004. 2004 U.S. App. Lexus 24763. Case 14.4. The issue is whether an employer's refusal to accommodate an employee's religious practice because of its provision prohibiting facial jewelry amounts to religious discrimination. Lipez, Circuit Judge. Kimberly Clowder alleges that her employer, Costco Wholesale Corporation, Costco, failed to offer her a reasonable accommodation after she alerted it to a conflict between the no facial jewelry provision of its dress code and her religious practice as a member of the Church of Body Modification. She argues that this failure amounts to religious discrimination in violation of Title VII. The district court granted summary judgment for Costco, concluding that Costco reasonably accommodated Clowder by offering to reinstate her if she either covered her facial piercing with a band-aid or replaced it with a clear retainer. Kimberly Clowder began working at Costco's West Springfield, Massachusetts store in July 1997. Before her first day of work, Clowder received a copy of the Costco employment agreement, which included the employee dress code. When she was hired, Clowder had multiple earrings and 4 tattoos, but no facial piercings. Clowder moved from her position as a front-end assistant to the deli department in September 1997. In 1998, Costco revised its dress code to prohibit food handlers, including deli employees, from wearing any jewelry. Clowder's supervisor instructed her to remove her earrings pursuant to the revised code, but Clowder refused. Instead, she requested to transfer to a front-end position where she would be permitted to continue
thrusters, so I
wearing
guess
her
that's
jewelry.
good. I have no
Clowder did not
storage,
indicate at the
though.
time that her insistence on wearing her earrings was based on a religious or spiritual belief. Costco approved Clowder's transfer back to a front-end position in June 1998 and promoted her to cashier soon thereafter. Over the ensuing 2 years, she engaged in various forms of body modification, including facial piercing and cutting. Although these practices were meaningful to Clowder, they were not motivated by a religious belief. In March 2001, Costco further revised its dress code to prohibit all facial jewelry, aside from earrings, and disseminated the modified code to its employees. Clowder did not challenge the dress code or seek an accommodation, but rather continued uneventfully to wear her eyebrow piercing for several months. Costco began enforcing its no facial jewelry policy in June 2001. On June 25, 2001, front-end
Cobalt paste. We need to
supervisors
go get
Todd
cobalt
Cunningham
paste.
and Michelle Callahan informed Clowder and another employee, Jennifer Theriac that they would have to remove their facial piercings. Cloutier and Theriac did not comply, returning to work the following day, still wearing their piercings. When Callahan reiterated the no facial jewelry policy, Cloutier indicated for the first time that she was a member of the Church of Body Modification, CBM, and that her eyebrow piercing was part of her religion. The CBM was established in 1999 and counts approximately 1,000 members who participate in such practices as piercing, tattooing, branding, cutting, and body manipulation. Among the goals espoused in the CBM's mission statement are for its members to grow as individuals through body modification and its teachings, to promote growth in mind, body and spirit, and to be confident role models in learning, teaching, and displaying body modification. The church's website, apparently its primary mode for reaching its adherents, did not state that members' body modifications had to be visible at all times, or that temporarily removing body modifications would violate a religious tenet. Still, Cloutier interprets the call to be a confident role model as requiring that her piercings be visible at all times and precluding her from removing or covering her facial jewelry. She does not extend this reasoning to the tattoos on her upper arms, which were covered at work by her shirt. After reviewing information that Cloutier provided from the CBM website, Callahan's supervisor, Andrew Mulick, instructed Cloutier and Theriac to remove their facial jewelry. They refused. The following day, Cloutier filed a religious discrimination complaint with the Equal Employment Opportunity Commission, EOC, which is empowered to enforce Title VII. When Cloutier returned to work for her next shift on June 29, 2001, she was still wearing her facial jewelry. She met with Mark Shevchuk, the store manager, about her membership in the CBM and the EOC complaint. During the course of the meeting, Cloutier suggested that she be allowed to cover her eyebrow piercing with a flesh-colored band-aid. Shevchuk rejected the suggestion and told Cloutier that she had to remove the piercing or go home. She left. The parties remained in contact after Cloutier's termination through the EOC mediation process. During a meeting on August 10, 2001, Costco offered to let Cloutier return to work wearing either plastic retainers or a band-aid over her jewelry, the same accommodation that Cloutier had suggested prior to her termination. Shevchuk repeated the offer in a letter dated August 29, 2001, asking Cloutier to respond by September 6, 2001. Although there is some dispute as to whether Cloutier attempted to respond to Costco's offer before the deadline, she now maintains that neither of the proffered accommodations would be adequate because the CBM's tenets, as she interprets them, require her to display all of her facial piercings at all times. Replacing her eyebrow piercing with a plastic retainer or covering it with a band-aid would thus contradict her religious convictions. Cloutier asserts that the only reasonable accommodation would be to excuse her from Costco's dress code, allowing her to wear her facial jewelry to work. Costco responds that this accommodation would interfere with its ability to maintain a professional appearance and would thereby create an undue hardship for its business. The EOC determined in May 2002 that Costco's actions violated Title VII of the Civil Rights Act of 1964. It found that Cloutier's refusal to remove her facial jewelry was religiously based as defined by the EOC, that Costco did not allow her to wear her facial jewelry at work, and that there was no evidence that allowing her to wear the jewelry would have constituted an undue hardship. Based on this determination, Cloutier filed a suit against Costco in federal district court in August 2002, alleging a Title VII violation. We find dispositive that the only accommodation Cloutier considers reasonable, a blanket exemption from the no facial jewelry policy, would impose an undue hardship on Costco. In such a situation, an employer has no obligation to offer an accommodation before taking an adverse employment action. Costco is far from unique in adopting personal appearance standards to promote and protect its image. Good grooming regulations reflect a company's policy in our highly competitive business environment. Reasonable requirements in furtherance of that policy are an aspect of managerial responsibility. Courts have long recognized the importance of personal appearance regulations, even in the face of Title VII challenges. Courts considering Title VII religious discrimination claims have also upheld dress code policies that, like Costco's, are designed to appeal to customer preference or to promote a professional public image. Cloutier's insistence on a wholesale exemption from the no facial jewelry policy precludes Costco from using its managerial discretion to search for a reasonable accommodation. Exempting Cloutier from the dress code would have imposed more than a de minimis burden on Costco for the reasons outlined above. Her refusal to consider anything less means that Costco could not offer a reasonable accommodation without incurring an undue hardship. For this reason, Cloutier's discrimination claim must fail. Affirmed. Case commentary. The First Circuit decided that granting Cloutier's request for an accommodation of her religious practice would place an undue burden on Costco's attempt to maintain personal appearance standards through the enforcement of its dress code. Case questions. Do you agree with the court's decision? Do you believe the Church of Body Modification is a religion? Under what circumstances would an exception be created to a dress code? What would be an ethical resolution to this case? Bobby T. Brown v. Bell Roberts and Company, Incorporated. 2008 Massachusetts Lexus 793, Supreme Judicial Court of Massachusetts. Case 14.5. The issue is whether an employer must create an exemption to its dress code for an employee due to his religious beliefs. Ireland, J. In June 2006, the plaintiff filed
I feel
a complaint
dumber
in the
for listening to
Superior
that
Court,
case.
claiming that a new grooming policy at one of the defendant's businesses, which required all employees who had customer contact to be clean-shaven, discriminated against him due to his religion. A Superior Court judge concluded that, as a matter of law, an exemption from the grooming policy would constitute an undue hardship because the defendant had a right to control its public image. Because the defendant did not engage in an interactive process to address the plaintiff's religious needs, it was the defendant's burden to prove conclusively that no other conceivable accommodation was possible without imposing an undue hardship. We conclude that, on the record before us, the defendant has not met its burden. Accordingly, we vacate the grant of summary judgment and remand the case for further proceedings consistent with this opinion. A three-part inquiry applies where an employee claims discrimination based on religion. The employee bears the initial burden of establishing a prima facie case that the employer required the employee to violate a required religious practice. The employee also must demonstrate that he or she gave the employer the required notice of the religious obligations. If the employee makes this prima facie case, the burden then shifts to the employer to prove that accommodation of the employee's religious obligations would impose an undue hardship pursuant to the statute. In determining whether an employer has met its burden of proving undue hardship, the focus is on the particular nature and operations of its business. Moreover, an employer's mere contention that it could not reasonably accommodate an employee is insufficient. The plaintiff worked in Hadley as a lube technician for a Jiffy Lube service station that was owned by the defendant, Jiffy Lube. The plaintiff worked on motor vehicles in the upper and lower bays. When he worked in the upper bay, he also worked as a greeter, salesperson, and cashier. In 2001, Richard Smith became the defendant's new vice president in charge of Jiffy Lube. Smith avers that he hired a consultant to help him develop strategies to improve sales and attract new customers to Jiffy Lube. As a result, in January 2002, Smith instituted a grooming policy that stated, "See, customer contact employees are expected to be clean-shaven with no facial hair. Hair should be clean, combed, and neatly trimmed or arranged. Radical departures from conventional dress or personal grooming and hygiene standards are not permitted." Other businesses owned by the defendant, including a retail gasoline station and convenience store, a restaurant, and a car wash, did not implement similar policies. The plaintiff is a practicing Rastafarian. His religion, to which he has adhered since 1991, does not permit him to shave or cut his hair. In light of the grooming policy, the plaintiff told Jiffy Lube's manager and assistant manager that he wished to maintain customer contact without having to shave or cut his hair. The plaintiff's concerns were communicated to Smith, who stated that if the plaintiff did not comply, he would be allowed to work only in the lower bay and could not have customer contact. The plaintiff also made his concerns known directly to Smith, who stated, according to the plaintiff, that he did not have time to check people's religions. Once the policy was implemented, the plaintiff worked solely in the lower bay with no formal customer contact. The plaintiff remained a lube technician and received a merit pay increase in January 2002. However, the plaintiff asserts that the working conditions in the lower bay were significantly worse than the upper bay, including that it was much colder in the winter and more dangerous. Because he was the sole lower bay employee on his shift, he could not take breaks and many times was the last person at lunch. There was no alternative to working in the lower bay if he wanted to keep his job. He also states that he saw many lube technicians who had grease on them when they had customer contact. The plaintiff ceased working for Jiffy Lube in May 2002, which, according to the judge, was for reasons unrelated to the litigation. In her written memorandum of decision, the judge stated that the sincerity of the plaintiff's religious beliefs are not disputed by the defendant, and that the plaintiff did inform the defendant of the requirements of his religion. The judge also concluded that the change in the plaintiff's job responsibilities was substantial enough for the plaintiff to meet his burden to show a prima facie case of discrimination due to his religion. The judge did not discuss directly whether the job change itself was a reasonable accommodation. Rather, the judge addressed the issue of undue hardship, focusing on whether the employer could have exercised its managerial discretion in such a way that the employee's religious obligations could have been reasonably accommodated. Undue hardship. We note that, in their briefs to this court, the parties focused solely on the undue hardship issue that was the basis for the judge's summary judgment decision. The defendant contends that, as a matter of law, it was not required to engage in an interactive process to find a reasonable accommodation for the plaintiff because, like the plaintiff in Cloutier, he requested an exemption from the grooming policy and thus foreclosed Jiffy Lube's ability to exercise its managerial discretion in such a way as to reasonably accommodate him. Here, because the defendant did not discuss alternatives with the plaintiff, the defendant cannot show conclusively, on this record, that a total exemption from the grooming policy was the only possible accommodation. Indeed, in his supplemental affidavit, the plaintiff asserts that he never said that he would not have considered suggestions by Jiffy Lube for an accommodation other than a complete exemption, and that he, in fact, would have considered other alternatives had they been offered. The defendant's reliance on the facts in Cloutier is misplaced. In any event, GLC 151B, Section 4(1)A, requires an employer to provide a reasonable accommodation unless there is an undue hardship. We conclude that the plaintiff's initial request for an exemption did not relieve the defendant of this obligation. All that was required of this plaintiff, initially, was that he make clear to Jiffy Lube that there was a conflict between the grooming policy and his religion. The specific content of the plaintiff's initial communication of that conflict is irrelevant. To hold otherwise would shift the statutory burden entirely to the employee, eviscerating the statutory requirement that an employer provide a reasonable accommodation. In addition, in purely practical terms, the employer is in as good, if not better, position to determine possible accommodations. We also conclude that an exemption from a grooming policy cannot constitute an undue hardship as a matter of law. Our cases have interpreted the statute to mean that an employer has the burden to prove undue hardship. In the absence of a search for a reasonable accommodation, an employer is required to conclusively demonstrate that all conceivable accommodations would impose an undue hardship on the course of its business. Such a demonstration is a factual inquiry. Blanket assertions that an employee's demand for relief is unreasonable are not enough. The defendant argues that a claim of the non-economic costs concerning public image should be sufficient to demonstrate undue hardship. It asserts, without citation to any authority, that to hold otherwise would be to impose a burden that is impossible for businesses to meet. We see no reason to make an exception to this well-established regime for a grooming policy. To do so would upset the balance between employer interests and employee needs that is built into the statute. Requiring proof of undue hardship protects against the misuse of public image and is consistent with the requirement that the statute be construed liberally to accomplish its ends. Finally, although EOC regulations are not entitled to any particular deference, we note our conclusion that an exemption from a grooming policy is not an undue hardship as a matter of law comports with an EOC compliance manual. When an employer has a dress or grooming policy that conflicts with an employee's religious beliefs or practices, the employee may ask for an exception to the policy as a reasonable accommodation. Religious grooming practices may relate, for example, to shaving or hair length. Religious dress may include clothes, head or face coverings, jewelry, or other items. Absent undue hardship, religious discrimination may be found where an employer fails to accommodate the employee's religious dress or grooming practices. EOC guidelines and compliance manuals are not accorded the same weight as regulations, but they may be used for guidance, and the weight of such a judgment in a particular case will depend upon the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all those factors which give it the power to persuade. Reasonable accommodation. The plaintiff argues that we should vacate the judgment of the Superior Court on the cross motions for summary judgment and grant his motion and deny the defendants. He argues that, because working in the lower bay was part of the grooming policy itself, it could not be considered a reasonable accommodation. However, the defendant contends that working in the lower bay was an accommodation and reserved the right to address this issue at trial. In addition, Smith states in his affidavit that the job responsibilities in the upper and lower bay are virtually identical. Because the material fact whether working in the lower bay was a reasonable accommodation for purposes of G.L.C. 151b, Section 4, 1a, is disputed, summary judgment is inappropriate. The issue needs to be resolved by the trier of fact, as we cannot say, on this record, that no reasonable jury could conclude that working in the lower bay was not a reasonable accommodation. Case commentary. The Supreme Court of Massachusetts decided that there should be a determination as to whether working in the lower bay was a reasonable accommodation. Case questions. Do you agree with the decision of the court? What more could the employer have done? Why should an employee's personal religious beliefs have to be accommodated? Raymond Jackson versus Light of Life Ministries Incorporated. 2006 U.S. DIST Lexus 75265, Western District, PA. Case 14.6. The issues are whether Light of Life Ministries is a religious organization and whether it can restrict its full-time hiring to members of its faith. Terrence F. McVeary, United States District Court Judge. Plaintiff Raymond Jackson was employed by Defendant Light of Life Ministries Incorporated, Light of Life, for approximately 2 years as a part-time program aide. Although the record does not describe the duties of a program aide, it is undisputed that Jackson's duties did not require him to provide religious counseling, conduct religious services, or participate in religious activities. Jackson is a Jehovah's Witness. Light of Life holds itself out as a Christian agency. Light of Life informed Jackson that he would not be hired for a full-time position because of his religion. In August 2004, Jackson filed charges with the Equal Employment Opportunity Commission, EOC, alleging religious discrimination for the failure to hire him full-time. Plaintiff alleges that Light of Life failed to hire him because of his religion, in violation of Title VII. Defendant cites to Section 2000 times 10 to the power of -1, which permits religious organizations to discriminate on the basis of religion. The dispositive issue regarding this motion is whether Light of Life is a religious organization as defined in Title VII. A mission statement and statement of faith were contained in the employee handbook that Jackson received at the time he was hired. The Light of Life mission statement was revised during Jackson's employment. Both versions explicitly refer to the religious mission of the organization. Light of Life Ministries is a private, nonprofit Christian agency dedicated to serving homeless and needy people of southwestern Pennsylvania by providing food, shelter, and hope through a continuum of outreach and residential programs. The organization will endure as a ministry grounded on the teachings of the Lord Jesus Christ and as a caregiver, advocate, and leader on behalf of homeless and needy people. As a ministry of Jesus Christ, Light of Life will provide a home for the homeless and food for the hungry, and will build disciples for the kingdom of God among the poor, addicted, abused, and needy. Plaintiff has submitted an EOC determination letter that concluded that Light of Life did not qualify for the religious exemption. Plaintiff also submitted a newspaper article stating, in relevant part, that 46 cents of every dollar donated to Light of Life went to a California fundraising company. That Light of Life owned 6 properties, including one that was rented to a business selling comic books, and that Light of Life received federal grants. Plaintiff contends that the job of Program Aid does not require him to provide religious counseling, conduct religious services, or participate in religious activities. Defendant does not contest this fact. Plaintiff further contends that he complied with defendant's Christian policies, for example by answering the telephone, "Christ is the answer, Light of Life mission." Congress created an exemption for religious organizations, stating that Title VII shall not apply to a religious corporation, association, educational institution, or society with respect to the employment of individuals of a particular religion to perform work connected with the carrying on by such corporation, association, educational institution, or society of its activities. In other words, a religious organization is permitted to discriminate on the basis of religion. The religious exemption is clearly at issue because the complaint alleges that Light of Life refused to hire Jackson because of his religion. The evidence that Light of Life is structured and holds itself out as a religious organization is simply overwhelming. The corporate acts of creating and adopting a statement of faith and a doctrinal statement should be dispositive evidence that an entity is religious. Moreover, the numerous explicit religious references in the articles of incorporation, mission statement, and core values are independently dispositive. Indeed, it is difficult to imagine what more an organization could reasonably do to proclaim its religious purpose. Plaintiff does not contest any of these facts, but instead contends that his specific job did not require participation in these religious activities. For the reasons set forth above, this is not the proper legal test. Even assuming, arguendo, that the facts contained in the newspaper article and EOC determination letter submitted by plaintiff were true, and giving plaintiff every reasonable inference therefrom, Light of Life would still be entitled to summary judgment. Similarly, even if the discovery sought by plaintiff were permitted and revealed that Light of Life had extensive real estate holdings, engaged in numerous business-related activities, and received little or no church funding, the legal analysis would not change. As the Supreme Court and Third Circuit have instructed, secular activities will not destroy an organization's religious character, and the religious exemption applies to all of its employees. Accordingly, the court concludes that there are no genuine issues of material fact regarding whether defendant is a religious organization, and Light of Life is entitled to the religious exemption as a matter of law. Case commentary. The Western District Court of Pennsylvania determined that the Light of Life Ministries is a religious organization, and that a religion can hire employees who are exclusively of its faith. Case questions. Do you agree that religious hiring is a BFOQ?
I think I need
What
to
if
go
the
get a
job,
bunch
such
of
as maintenance, has
aluminum
no relation
now.
to the religious practices? How does this case correlate with the soccer camp employment perspective feature in this chapter? What would be an ethical resolution
Oh,
to this
I need to
dilemma?
get storage containers.
Summary.
That's what we're doing.
Employers should not pry into the personal lives of their employees any more than they would like their employees seeking personal information about them or their top executives. Religious belief is not related to job performance. Thus, employers have no right to discriminate because of religion. Employers need
Yeah, I need
only
to go get a
consider
bunch of
global trade
aluminum.
to understand why it is important to avoid religious discrimination. It would be a foolish thought for an employer to trade only with countries having the same religion as the employer. Further, if an employer establishes a subsidiary overseas or otherwise employs foreign people to work on its behalf, it would be nearly impossible to discriminate on the basis of religion, race, or national origin. Religious discrimination is rendered impracticable in a global environment. The same philosophy should apply domestically. The practice of any form of discrimination weakens the employer by narrowing the pool of qualified candidates available for the job. Human resource advice. Decide what religious accommodations to provide for your employees. Realize that you cannot discriminate in making an employment decision because of the religion of an applicant or an employee. Recognize that food safety is paramount to religious practices involving facial hair or hair length. Learn the significance of the First Amendment of the U.S. Constitution for religion. Know that religion is a protected class under Title VII of the Civil Rights Act. Understand that you do not have to permit the conducting of religious services at the workplace. Be aware that you do not have to allow employees to promote their religious or political beliefs at the workplace. Be cognizant of the fact that religious institutions may employ members of their own faith to promote their religion. Acknowledge that a person's religion has no bearing on his or her ability to perform a job.
Well, there's chapter 14 done. So let's get 15 going. Welcome back. Thank you.
Chapter Checklist. Chapter 15 National Origin Discrimination. Chapter Checklist. Define national origin. Know what rights to employment are afforded to resident aliens. Learn that discrimination against an applicant or employee because of his or her spouse's national origin is a violation of Title VII. Appreciate that discrimination against people because of the national origin of their surname is impermissible. Be aware of the documentation required to work in this country. Understand that national origin is a suspect class covered under Title VII of the Civil Rights Act. Be apprised of the purpose of the Immigration Reform and Control Act. Be familiar with the number of employees required for the application of each act. Recognize that the Immigration Reform and Control Act applies to all workers employed in the United States, but it has no application to U.S. workers employed abroad. Realize what is required to bring a disparate treatment case for national origin discrimination. In the news. In a lawsuit in California filed against their employer, Molina Healthcare, and its outsourcer, Cognizant Technology
I'm already going to
Solutions,
hate doing
by
this.
18 IT workers, they claim that their employer discharged them after recruiting foreign workers holding H-1B visas. The American workers each earned at least $75,000 in annual salary. Their foreign counterparts were hired for much less. James Otto, attorney for the 18 discharged American workers, stated that Indian supervisors mandated that American employees complete work projects over major American holidays, thus prohibiting them from engaging in traditional celebrations. Molina employs more than 4,200 workers. It claims
gotta
that
go make a
only
bunch of
small
aluminum.
percentage of its employees are foreign workers holding H-1B visas. Molina claimed that the foreign workers were needed to fill gaps in its employment requiring special skills. James Otto retorted that Molina's justification was a facade. Its main intent, Otto said, was to displace American workers earning high wages with foreign workers who will accept substantially less compensation. After Cognizant received approval of 40 H-1B visas, Molina terminated 40 employees, including managers, security analysts, and programmers, all of which were well-paid white-collar positions. Cognizant is named as a defendant in the lawsuit for failing to seek out Americans for vacant positions. Molina denied the allegation. The lawsuit also alleges that the H-1B employees were paid roughly half of what the discharged workers received. Do you believe foreign workers should be granted visas to replace American workers for the sole reason of saving on labor costs? Source: Patrick Thibodeau. Fired IT workers file lawsuit claiming H-1B workers replace them. Workers file suit against Molina Healthcare and its outsourcer, Cognizant, Computer World, July 12, 2011. http://www.computerworld.com/s/article/9218349/?taxonomy ID =72 page number =1. Introduction. Case 15.3, 15.4. Individuals are protected from discrimination based on national origin under Title VII of the Civil Rights Act and the Immigration Reform and Control Act of 1986. National origin refers to a person's roots, that is, the country in which the person or the person's ancestors were born. The four-step test for national origin discrimination is as follows. The employee belongs to the protected class. The employee wanted to retain or obtain the position. The employee was terminated or the applicant was refused employment. Termination or refusal to hire occurs because of the employee's or applicant's national
All right, I need to go
origin.
get aluminum.
Employment perspective. Manolo Fuentes is Spanish-American.
Let
His
me
ancestors came
go
from Spain. When Fuentes
to,
applies for a position as a stockbroker with Bull and Bear after graduating at the top of his university class, he is offered a job in the mailroom. When he questions this offer, a manager from Bull and Bear tells him, "This is where you Puerto Ricans belong." Fuentes corrects Bull and Bear about his heritage, but the manager retorts, "You are all the same." Fuentes argues that it should not matter whether he is from Spain, Puerto Rico, Mexico, or elsewhere in Latin America, and that he should be judged on the basis of his qualifications, not regional or ethnic stereotypes. Will Fuentes win? Yes. Offering a person a low-level position solely because he or she is from Spain, Puerto Rico, Mexico, or elsewhere in Latin America is in violation of Title VI's prohibition against national origin discrimination. National origin, manager from Bull and Bear tells him, refers to a person's roots, that is, the country in which the person or the person's ancestors were born. Discrimination against a person for his or her own national origin is not the only prohibition. The issue can also be raised by an employee or applicant who is discriminated against because of his or her spouse's national origin, membership in an association of a particular national origin, attendance at a school or religious institution identified with people of a specific national origin, or the association of his or her name with persons of a particular
I have to redo my
national
drinking
origin.
buttons in a
Immigration
little bit here.
Reform and Control Act, Case 15.1. The Immigration Reform and Control Act, IRCA of 1986, which applies to employers with 4 or more employees, prohibits discrimination for national origin or for citizenship when the latter is an alien lawfully admitted for permanent residence. Whereas Title VII affords no protection against discrimination based on citizenship or against employers of 4 to 14 employees, IRCA does. However, IRCA makes no provision for the disparate impact that occurs unintentionally, as does Title VII. Intent to discriminate is mandated by ICA, which has been amended by the Immigration Act of 1990. IRCA applies to foreign and domestic companies and organizations that employ people within the United States. It has no application to U.S. workers who are employed abroad by foreign or domestic companies and organizations. Employment perspective. The law firm of Knapp and Schultz has 12 employees. Knapp and Schultz has a policy never to hire anyone who is not a U.S. citizen.
Wait, hold on a second. What the hell?
Employment perspective. The law firm of Knapp and Schultz has 12 employees. Knapp and Schultz has a policy never to hire anyone who is not a U.S. citizen. Prasad Thisawat, a permanent resident alien from Thailand, applies for a job with Knapp and Schultz only to be informed of its policy. Thisawat claims that Knapp and Schultz is in violation of IRCA. Is he correct? Yes. IRCA prohibits discrimination against permanent resident aliens and applies to employers with at least 4 employees. Even if Congress has not explicitly provided for preemption in a given statute, the Supreme Court, Ha-S, found that state law must yield to a congressional act in at least 2 circumstances. First, W, when Congress intends federal law to occupy the field, state law in that area is preempted. Second, even if Congress has not occupied the field, state law is naturally preempted to the extent of any conflict with a federal statute. Conflict preemption, in turn, has 2 forms: impossibility and obstacle preemption. Impossibility preemption exists where it is impossible for a private party to comply with both state and federal law. Obstacle preemption exists where, under the circumstances of a particular case, the challenged state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. To determine whether obstacle preemption exists, the Supreme Court has instructed that we employ our judgment to be informed by examining the federal statute as a whole and identifying its purpose and intended effects. Section 2B of Arizona's law provides, for any lawful stop, detention, or arrest made by an Arizona law enforcement official or a law enforcement agency in the enforcement of any other law or ordinance of a county, city, or town of this state where reasonable suspicion exists that the person is an alien and is unlawfully present in the United States, a reasonable attempt shall be made, when practicable, to determine the immigration status of the person, except if the determination may hinder or obstruct an investigation. Any person who is arrested shall have the person's immigration status determined before the person is released. The person's immigration status shall be verified with the federal government. A person is presumed to not be an alien who is unlawfully present in the United States if the person provides to the law enforcement officer or agency any of the following: a valid Arizona driver license, a valid Arizona non-operating identification license, a valid tribal enrollment card or other form of tribal identification. If the entity requires proof of legal presence in the United States before issuance, any valid United States federal, state, or local government issued identification. We begin with the purpose of Congress by examining the text of the INA, titled Performance of Immigration Officer Functions by State Officers and Employees. Congress has instructed under what conditions state officials are permitted to assist the executive in the enforcement of immigration laws. Congress has provided that the Attorney General may enter into a written agreement with a state, pursuant to which an officer or employee of the state who is determined by the Attorney General to be qualified to perform a function of an immigration officer in relation to the investigation, apprehension, or detention of aliens in the United States, may carry out such function. These provisions demonstrate that Congress intended for states to be involved in the enforcement of immigration laws under the Attorney General's close supervision. Not only must the Attorney General approve of each individual state officer, he or she must delineate which functions each individual officer is permitted to perform. In sum, Congress intended for state officers to systematically aid in immigration enforcement only under the close supervision of the Attorney General, to whom Congress granted discretion in determining the precise conditions and direction of each state officer's assistance. We find it particularly significant for the purposes of the present case that this discretion includes the Attorney General's ability to make an individual officer's immigration enforcement duties permissive or mandatory. By imposing mandatory obligations on state and local officers, Arizona interferes with the federal government's authority to implement its priorities and strategies in law enforcement, turning Arizona officers into state-directed DHS agents. As a result, Section 2(b) interferes with Congress's delegation of discretion to the executive branch in enforcing the INA. In light of the foregoing, we conclude that the United States has met its burden to show that there is likely no set of circumstances under which SB 1070 Section 2(b) would be valid, and it is likely to succeed on the merits of its challenge. The District Court did not abuse its discretion by concluding the same. SB 1070 Section 3 provides, in addition to any violation of federal law, a person is guilty of willful failure to complete or carry an alien registration document if the person is in violation of 8 United States Code Section 1304(e) or 1306(a). The penalty for violating Section 3 is a maximum fine of $100, a maximum of 20 days in jail for a first violation, and a maximum of 30 days in jail for subsequent violations. Section 3 does not apply to a person who maintains authorization from the federal government to remain in the United States. Section 3 essentially makes it a state crime for unauthorized immigrants to violate federal registration laws. Starting with the touchstones of preemption, punishing unauthorized immigrants for their failure to comply with federal registration laws is not a field that states have traditionally occupied. Therefore, we conclude that there is no presumption against preemption of Section 3. Arizona argues that Section 3 is not preempted because Congress has invited states to reinforce federal alien classifications. Attempting to support this argument, Arizona cites INA sections outside the registration scheme where Congress has expressly indicated how and under what conditions states should help the federal government in immigration regulation. The sections Arizona cites authorize states to limit certain immigrants' eligibility for benefits and to impose sanctions on employers who employ unauthorized immigrants. We are not persuaded by Arizona's argument. An authorization from one section does not, without more, carry over to other sections. Nothing in the text of the INA's registration provisions indicates that Congress intended for states to participate in the enforcement or punishment of federal immigration registration rules. In addition, SB 1070 Section 3 plainly stands in opposition to the Supreme Court's direction, where the federal government, in the exercise of its superior authority in this field, has enacted a complete scheme of regulation and has therein provided a standard for the registration of aliens. States cannot, inconsistently with the purpose of Congress, conflict or interfere with, curtail or complement the federal law, or enforce additional or auxiliary regulations. In light of the foregoing, we conclude that the United States has met its burden to show that there is likely no set of circumstances under which SB 1070 Section 3 would be valid, and it is likely to succeed on the merits of its challenge. The District Court did not abuse its discretion by concluding the same. SB 1070 Section 5(c) provides that it is unlawful for a person who is unlawfully present in the United States and who is an unauthorized alien to knowingly apply for work, solicit work in a public place, or perform work as an employee or independent contractor in this state. Violation of this provision is a Class 1 misdemeanor, which carries a 6-month maximum term of imprisonment. Thus, Section 5(c) criminalizes unauthorized work and attempts to secure such work. We have previously found that because the power to regulate the employment of unauthorized aliens remains within the state's historic police powers, an assumption of non-preemption applies here. Therefore, with respect to SB 1070 Section 5(c), we start with the assumption that the historic police powers of the states were not to be superseded by the federal act unless that was the clear and manifest purpose of Congress. Within the INA, Congress first tackled the problem of unauthorized immigrant employment in the Immigration Reform and Control Act of 1986, IRCA. We have previously reviewed IRCA's legislative history and Congress's decision not to criminalize unauthorized work. Therefore, our decision requires us to conclude that federal law likely preempts SB 1070 Section 5(c), since the state law conflicts with what we have found was Congress's IRCA intent. The text of the relevant IRCA statutory provision also supports this conclusion. Section 1324(a) establishes a complex scheme to discourage the employment of unauthorized immigrants, primarily by penalizing employers who knowingly or negligently hire them. The statute creates a system through which employers are obligated to verify work authorization. The verification process includes a requirement that potential employees officially attest that they are authorized to work. The statute provides that the forms potential employees use to make this attestation may not be used for purposes other than for enforcement of this chapter. These sections of Title 18 criminalize knowingly making a fraudulent statement or writing, knowingly making or using a false or stolen identification document, forging or falsifying an immigration document, and committing perjury by knowingly making a false statement after taking an oath in a document or proceeding to tell the truth. This is the exclusive punitive provision against unauthorized workers in 8 U.S.C. Section 1324A. All other penalties in the scheme are exacted on employers, reflecting Congress's choice to exert the vast majority of pressure on the employer side. In addition, other provisions in 8 U.S.C. Section 1324A provide affirmative protections to unauthorized workers, demonstrating that Congress did not intend to permit the criminalization of work. Subsection 1324A D2C provides that a New York personal information utilized by the authorization verification system may not be made available to government agencies, employers, and other persons except to the extent necessary to verify that an individual is not an unauthorized alien. This provision would prohibit Arizona from using personal information in the verification system for the purpose of investigating or prosecuting violations of SB 1070 Section 5C. Subsection 1324A D2F provides in even clearer language that T verification system may not be used for law enforcement purposes, other than for enforcement of this chapter or the aforementioned Title 18 fraud sections. Subsection 1324A G1 demonstrates Congress's intent to protect unauthorized immigrant workers from financial exploitation, a burden less severe than incarceration. This section provides that it is unlawful for a person or other entity in the hiring of any individual to require the individual to post a bond or security, to pay or agree to pay an amount, or otherwise to provide a financial guarantee or indemnity against any potential liability arising under this section relating to such hiring of the individual. Subsection 1324AE provides for a system of complaints, investigation, and adjudication by administrative judges for employers who violate subsection G1. The penalty for a violation is $1,000 for each violation and an administrative order requiring the return of any amounts received to the employee or, if the employee cannot be located, to the general fund of the Treasury. 8 U.S.C. Section 1324AG2. Here, Congress could have required that employers repay only authorized
Man,
workers
there's
from whom they
hardly
collected
any
financial
aluminum
bond.
here.
Instead, Congress required employers to repay any employee, including undocumented employees. Where Congress did not require undocumented workers to forfeit their bonds, we do not believe Congress would sanction the criminalization of work. We therefore conclude that the text of 8 U.S.C. Section 1324A, combined with legislative history demonstrating Congress's affirmative choice not to criminalize work as a method of discouraging unauthorized immigrant employment, likely reflects
that base is
Congress's
gone.
clear and manifest
Wow.
purpose to supersede state authority in this context. Here, Congress's inaction in not criminalizing work, joined with its action of making it illegal to hire unauthorized workers, justifies a preemptive inference that Congress intended to prohibit states from criminalizing work. Congress has not withdrawn all substantial involvement in preventing unauthorized immigrants from working in the United States. It has simply chosen to do so in a way that purposefully leaves part of the field unregulated. We are also guided by the Supreme Court's recognition, even before our CA, that a primary purpose in restricting immigration is to preserve jobs for American workers. As Arizona states, Section 5C clearly furthers the strong federal policy of prohibiting illegal aliens from seeking employment in the United States. The Supreme Court has cautioned, however, that conflict in technique can be fully as disruptive to the system Congress erected as conflict in overt policy. In the context of unauthorized immigrant employment, Congress has deliberately crafted a very particular calibration of force, which does not include the criminalization of work. By criminalizing work, SB 1070 Section 5C constitutes a substantial departure from the approach Congress has chosen to battle this particular problem. Therefore, Arizona's assertion that this provision furthers the strong federal policy.
Man, there's a
does not
lot of
advance its
bases that
argument
aren't here
against
anymore.
preemption.
A lot of
Sharing
people
a goal
not
with
playing the
United
game
States
anymore.
does not permit Arizona to pull levers of influence that the federal act does not reach. By pulling the lever of criminalizing work, which Congress specifically chose not to pull in the INA Section 5C, stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. It is therefore likely that federal law preempts Section 5C. In addition, as detailed with respect to Section 2B above, SB 1070's detrimental effect on foreign affairs, and its potential to lead to 50 different state immigration schemes piling on top of the federal scheme, weigh in favor of the preemption of Section 5C. In light of the foregoing, we conclude that the United States has met its burden to show that there is likely no set of circumstances under which SB 1070 Section 5C would not be preempted, and it is likely to succeed on the merits of its challenge. The District Court did not abuse its discretion by concluding the same. We have found that it is clear that it would not be equitable or in the public's interest to allow the state to violate the requirements of federal law, especially when there are no adequate remedies available. In such circumstances, the interest of preserving the supremacy clause is paramount. Accordingly, we find that as to the SB 1070 sections on which the United States is likely to prevail, the district court did not abuse its discretion in finding that the United States demonstrated that it faced irreparable harm, and that granting the preliminary injunction properly balanced the equities and was in the public interest. SB 1070 Section 6 provides that a peace officer, without a warrant, may arrest a person the officer has probable cause to believe. The person to be arrested has committed any public offense that makes the person removable from the United States. Conclude, as the district court did, that Section 6 provides for the warrantless arrest of a person where there is probable cause to believe the person committed a crime in another state that would be considered a crime if it had been committed in Arizona, and that would subject the person to removal from the United States. Section 6 also allows for warrantless arrests when there is probable cause to believe that an individual committed a removable offense in Arizona, served his or her time for the criminal conduct, and was released. And when there is probable cause to believe that an individual was arrested for a removable offense but was not prosecuted. Thus, the question we must decide is whether federal law likely preempts Arizona from allowing its officers to effect warrantless arrests based on probable cause of removability. Because arresting immigrants for civil immigration violations is not a field which the states have traditionally occupied, we do not start with the presumption against preemption of Section 6. Moreover, none of the circumstances in which Congress has permitted federal DHS officers to arrest immigrants without a warrant are as broad as Section 6. Absent a federal officer actually viewing an immigration violation, warrantless arrests under 8 U.S.C. Section 1357A require a likelihood that the immigrant will escape before a warrant can be obtained. Section 6 contains no such requirement, and we are not aware of any INA provision indicating that Congress intended state and local law enforcement officers to enjoy greater authority to effectuate a warrantless arrest than federal immigration officials. Thus, Section 6 significantly expands the circumstances in which Congress has allowed state and local officers to arrest immigrants. Federal law does not allow these officers to conduct warrantless arrests based on probable cause of civil removability, but Section 6 does. Therefore, Section 6 interferes with the carefully calibrated scheme of immigration enforcement that Congress has adopted, and it appears to be preempted. Arizona suggests, however, that it has the inherent authority to enforce federal civil removability without federal authorization, and therefore that the United States will not ultimately prevail on the merits. We do not agree. Contrary to the state's view, we simply are not persuaded that Arizona has the authority to unilaterally transform state and local law enforcement officers into a state-controlled DHS force to carry out its declared policy of attrition. In sum, we are not persuaded that Arizona has the inherent authority to enforce the civil provisions of federal immigration law. Therefore, Arizona must be federally authorized to conduct such enforcement. Congress has created a comprehensive and carefully calibrated scheme and has authorized the executive to promulgate extensive regulations for adjudicating and enforcing civil removability. SB 1070 Section 6 exceeds the scope of federal authorization for Arizona's state and local officers to enforce the civil provisions of federal immigration law. Section 6 interferes with the federal government's prerogative to make removability determinations and set priorities with regard to the enforcement of civil immigration laws. Accordingly, Section 6 stands as an obstacle to the full purposes and objectives of Congress. In addition, as detailed with respect to Section 2(b) above, SB 1070's detrimental effect on foreign affairs, and its potential to lead to 50 different state immigration schemes piling on top of the federal scheme, weigh in favor of the preemption of Section 6. In light of the foregoing, we conclude that the United States has met its burden to show that there is likely no set of circumstances under which SB 1070 Section 6 would be valid, and it is likely to succeed on the merits of its challenge. The district court did not abuse its discretion by concluding the same. For the foregoing reasons, we affirm the preliminary injunction enjoining enforcement of SB 1070 Sections 2(b), 3, 5, C, and 6. Judgment for the United States. Case commentary. The Ninth Circuit ruled in favor of the United States, stating that the federal government alone can regulate immigration. In 2012, the U.S. Supreme Court affirmed that part of the Ninth Circuit's decision that the federal government alone can regulate immigration and alien status. Case questions. Are you in agreement with the decision of the court? If the United States neglects to enforce its immigration laws, may a state undertake the role of enforcer? Is there an ethical resolution to this dilemma? Anthony Gerard Krokock versus Eric H. Holder, Jr., U.S. Attorney General. 670F.3D400, 2012 U.S. App, Lexus 3731, Second Circuit. Case 15.2. The issue is whether an individual who falsely states that he or she is a citizen is ineligible to work within the United States. Per curiam. Petitioner Anthony Gerard Krokock petitions for review of an order of the Board of Immigration Appeals, BIA, affirming an immigration judge's, IJ, determination that Krokock was ineligible for adjustment of status. The IJ determined that Krokock failed to meet his burden of demonstrating that he was not inadmissible under Immigration and Nationality Act, INA, for falsely representing himself as a United States citizen for the purpose of any benefit under the INA. Krokoc had checked the box on an I-9 employment eligibility form, I-9, indicating that he was a citizen or national of the United States when he applied for a job. Krokoc argues that he checked the citizen or national box on the I-9 with the intent of claiming nationality, and that due to the ambiguity of the statement, the I-9 alone is insufficient to establish his inadmissibility. Because
God,
it
I
is
work with
Krokoc's burden to
I-9s
demonstrate
all the
that
time.
he is not inadmissible, we find no error in the agency's determination and deny the petition for review. In January 2004, Krokoc, a native and citizen of Ireland, entered the United States on a non-immigrant student visa to complete a paramedic certification program. Following completion of his paramedic course and training and the subsequent expiration of his student visa and work authorization, Krokoc applied for and, in October 2004, obtained a position with the fire department in Saco, Maine. In order to obtain this position, Krokoc completed an I-9 attesting to his employment eligibility by checking the box on the form labeled citizen or national. In April 2006, based on a tip from a confidential informant, Krokoc was charged by the Department of Homeland Security with removability for remaining in the United States beyond the authorized period as an alien who falsely represented himself to be a citizen of the United States for any purpose or benefit under the INA. Shortly thereafter, Krokoc pled guilty in the United States District Court for the District of Maine to making a false attestation on an employment verification system form, and was subsequently charged with an additional ground of removability for having been convicted of a crime involving moral turpitude. Before the IJ, Krokoc conceded that he was removable for remaining in the United States beyond the authorized period, and he applied for adjustment of status based on his June 2006 marriage to a United States citizen. In November 2008, the IJ found Krokoc removable based on his overstay and his conviction, which the IJ determined to be a crime involving moral turpitude. The IJ further found that Krokoc was ineligible for an adjustment of status because he was inadmissible as an alien who falsely represented himself to be a citizen of the United States. The IJ found that Krokoc had not demonstrated that he was admissible because, although Krokoc claimed to have believed that he was a national when he checked the box on the I-9, Krokoc had admitted to an immigration officer that he had falsely claimed to be a United States citizen, offered confusing testimony as to whether he believed he was a national of the United States, and pled guilty to making a false attestation on the I-9. Krokoc appealed the IJ's decision to the BIA, which affirmed the IJ's decision in February 2011 and dismissed Krokoc's appeal. Krokoc now argues that the I-9 is ambiguous as to whether an individual who checks the citizen or national box makes a representation of citizenship, and argues that he claimed, falsely or otherwise, to be a national and not a United States citizen on the I-9. He concludes that he is admissible to the United States and eligible for adjustment of status because applies only to false claims of United States citizenship. Under the circumstances of this case, we review the decision of the IJ. To qualify for adjustment of status, an alien must demonstrate that he is admissible to the United States for permanent residence. Because applicants for adjustment of status are assimilated to the position of aliens seeking entry into this country, such aliens must show that they are clearly and beyond doubt entitled to be admitted. As Krokoc sought relief from removal in the form of adjustment of status, he was required to demonstrate that he did not falsely represent himself to be a U.S. citizen.
Oh
Krokoc
wow, I'm
argues that his
half
attestation to being
on
a
my
citizen
water
or
capacity.
national on the I-9 is alone insufficient to establish his inadmissibility because he checked the box while claiming to be a national, which is not a ground of inadmissibility. Krokoc correctly argues that a false claim of nationality, made either intentionally or mistakenly, does not render an alien inadmissible. However, the burden of demonstrating admissibility is squarely on appellant. Here, Krokoc was required to prove a negative, that he did not falsely claim United States citizenship. We find no error in the agency's determination that he failed to meet his burden. Because the I-9 shows that Krokoc claimed to be a citizen or national, he had the burden of showing that he claimed to be a national, not a citizen. Krokoc points to no evidence beyond his testimony to demonstrate that he thought he was a national when completing the I-9. Furthermore, his assertion that he was claiming to be a national at the time he completed the I-9 is undermined by his later admission before the IJ that he did not believe himself to be a national, as well as his prior statement to an immigration officer in which he characterized himself as a United States citizen in order to obtain his dream job. Ultimately, because Krokoc bears the burden of demonstrating that he did not falsely claim to be a United States citizen, and because he points to no additional evidence supporting his claim that he believed he was a U.S. national, we find no error in the agency's conclusion that Krokoc failed to carry his burden of establishing admissibility. Judgment for Holder was that Krokoc claimed to be a citizen or not. Case commentary. The Second Circuit ruled that Krokoc had not satisfied the criteria required to work in the United States. Case questions. Are you in agreement with the decision of the court? Does Krokoc's mistaken belief that he was a national have any validity? Is there an ethical resolution to this case? Jorge L. Cologne versus Illinois Bell Telephone Company D/B/A/SBC/Ameritech. 2009 U.S. DIST Lexus 89570. Northern District Court of Illinois. Eastern DIV. Case 15.3. The issue is whether a Hispanic worker was terminated because of his national origin or his insubordination. Gottschall, United States District Judge. While working at IBTC, Cologne worked as a sale and service representative. He answered phone calls from IBTC customers. At the location where Cologne worked, sale and service representatives were split into two groups, the bilingual group and the English-only group. Cologne is fluent in English and Spanish and was assigned to the bilingual group. When Cologne was originally hired, he handled calls from Spanish speakers only and only from the state of Illinois. In 2003, Cologne started being required to answer questions from callers who spoke either English or Spanish and who resided in Illinois or in other states. These changes were not unique to Cologne. Cologne worked in the bilingual group, and these changes applied to all members of that group. In contrast, and as its label suggests, the English-only group answered calls only in English, and any member of that group would answer calls from one state only. From this, Cologne contends that he and other members of the bilingual group had to work harder than the English-only group because they had to, 1, answer calls in multiple languages, and 2, answer calls from multiple jurisdictions. This latter point is relevant because different states have different service plans, rules, notices, and regulations which may need to be relayed to the customer. Cologne was required to answer calls from both Illinois and Ohio, but each required specific knowledge and training. However, and pursuant to a collective bargaining agreement, a sales and service representative is paid the same irregardless of the group to which she is assigned. Cologne was paid the same as an English-only group employee, though there was some pay variation, based on factors such as years of employment. Cologne performed his job adequately for approximately 9 months starting in January 2005, except for the attendance problems noted above. During this time, Cologne contends that he received calls only from Illinois customers and did not have to answer any calls from other states. The reason for this, whether it was an intentional act by IBTC or whether it was just a random event, is unclear from the record. At some point in later September or early October 2005, however, Cologne received a call from a customer in Ohio. He did not answer this caller's question, but instead returned the caller to the queue, requiring that it be answered by another sale and service representative. Cologne had previously been trained to handle calls from Ohio, but maintains that he was uncomfortable responding to calls from Ohio at that time. Cologne does not provide an explicit reason, but the inference suggested is that he was no longer familiar with the rules specific to answering calls from Ohio. A meeting was held on October 7, 2005 regarding Cologne's failure to answer calls from Ohio. Representatives from IBTC, from the union, and Cologne were in attendance. The parties dispute precisely what was said at the meeting, but there is no dispute that Cologne stated he did not believe it was fair that the bilingual group had to answer calls from multiple states without the benefit of additional compensation, and that he felt he could not properly answer Ohio calls because he had not received Ohio calls for some time. At that meeting, all agreed that Cologne would receive refresher training on how to handle calls from Ohio and would handle them in the future. The union representative also stressed that Cologne was obligated to answer calls from Ohio. The refresher training was to occur on October 12, 2005, but on that date Cologne refused to take the training, claiming that he was waiting to hear back from his union representative. Cologne was placed on unpaid suspension for insubordination on the same day he refused to take the refresher training. He was terminated on October 28, 2005, for the stated reason of insubordination. Regarding the allegation of retaliation, he cites the following facts. First, he wrote an open letter in 2004 arguing that the bilingual group was not being treated fairly and that it should either be paid more or be given work terms equal to those of the English-only group. This letter was circulated among coworkers and was sent to the union, though it was not directly sent to IBTC management. Second, during meetings in October 2005 regarding Cologne's failure to answer the call from Ohio, Cologne expressed directly to IBTC management that the bilingual group was not being treated fairly. Third, Cologne stated in his deposition that his union representative warned him a month before he was terminated that he was making things hard for himself by speaking out about the injustices he perceived the bilingual group was suffering. Cologne contends that he suffered discrimination on the basis of his national origin because of the changes in policy at IBTC in 2003 regarding the duties and obligations of the bilingual group. The record is silent regarding the national origin of the members of the bilingual and English-only groups, and neither party had addressed this issue. The court will assume for the purposes of this order that the bilingual group is exclusively Hispanic and the English-only group is exclusively non-Hispanic, which could give rise to an assumption that discrimination on the basis of bilingual ability is a pretext for discrimination on the basis of national origin. Title VII requires that the employee suffer a materially adverse employment action, regardless of whether the individual is proceeding under the direct or indirect method of proof. Cologne suffered no materially adverse employment action by virtue of the treatment of the bilingual group. At worst, he was required to answer calls in multiple languages, as opposed to just one language as in the English-only group, and answer calls from multiple states, as opposed to just one state as in the English-only group. Cologne admits that he was not required to work additional hours, and he admits that IBTC would, and did, provide training so that he would be able to answer calls from the states for which he was responsible. Unquestionably, Cologne's job was more challenging than was the job of a sales and service representative in the English-only group, but the additional obligations placed upon Cologne are not sufficient, either quantitative LY or qualitative LY, to qualify as a materially adverse employment action. A materially adverse change must be more than an inconvenience or a change in job responsibilities. The change must significantly alter the terms and conditions of the employee's job. Harder work assignments are insufficient. After the 2003 change in policy, the core aspects of Cologne's job were the same. He was still obligated to answer calls in the order received. He was still working the same number of hours. He was still obligated to speak in a language in which he was fluent and to answer questions for which he had received adequate training. Every adverse change in employment is not necessarily materially adverse under Title VII, and the facts here fall short of establishing a materially adverse action. IBTC's motion for summary judgment
chicken
on
butt?
Cologne's Title VII discrimination claim is granted. Case commentary. The Northern District Court of Illinois, Eastern Division, reasoned that a change of responsibilities alone is not indicative of discrimination. Case questions. Do you agree with the reasoning of the court? Is it ethical that the bilingual workers were not paid an additional sum for their extra responsibilities? Is speaking with bilingual customers truly extra work? Ollie Isker versus Henry M. Paulson, Jr., Secretary, Department of the Treasury, United States District Court for the District of Columbia. 580F, Sup. 2D30, 2008 U.S. DIST Lexus 73279, D.C. Case 15.4. The issue is whether the Department of the Treasury acted for security reasons or for ethnic discriminatory reasons against an employee with an Afghan heritage. Leon, United States District Judge. Plaintiff has been employed by the Bureau of Engraving and Printing, Bureau, a division of the Department of the Treasury, since 1995. During his tenure, plaintiff has filed a bevy of EO complaints. Indeed, the claims alleged in this action were the basis of an EO complaint filed by Isker on March 4, 2005. In that complaint and in this action, plaintiff, a Muslim male and native of Afghanistan, raises various discrimination claims, primarily arising from a security investigation related to his extended trip to Afghanistan in 2004. In June 2004, plaintiff requested leave without pay, LWP, from July 15, 2004 to December 31, 2004, to travel to Afghanistan for family matters. Isker told another supervisor, Felicia Jackson, that he needed to travel to Afghanistan because his mother was ill. Pursuant to the Bureau's policy that supervisors report extended foreign travel by Bureau employees to the Office of Security, Brent notified that office about Isker's foreign travel. Glenn Alonso of the Office of Security, was assigned to look further into Isker's trip to Afghanistan. After learning from Brent that Isker attributed his need to travel to his mother's health, Alonso reviewed Isker's security folder and discovered that Isker's mother was deceased. Because of this discrepancy and the fact that Isker was traveling to a country in which the United States is engaged in armed conflict, Alonso became suspicious and decided that a further investigation into the matter was warranted. Accordingly, he decided to redline Isker's entry badge and deprive him access to the agency until this issue was resolved. Consequently, when Isker returned to the Bureau on November 8, 2004, several weeks before the end of his LWP period, he was denied entry into the building. Alonso then met Isker at the entrance of the building and escorted him to the Office of Security for an interview. 3 days later, on November 26, 2004, Isker was cleared to return to work and did so on November 29, 2004. Plaintiff contends that the security investigation was a discriminatory action undertaken because of his race, color, national origin, and religion, and made in retaliation for previous EO actions. Plaintiff additionally alleges that the security investigation, along with several other incidents, created a hostile work environment. To support his claim that the Bureau was motivated by discriminatory intent, plaintiff alleges that Bureau employees lied about the underlying reasons for reporting his foreign travel to the Office of Security. Specifically, plaintiff claims that here were no discrepancies in the reasons for his travel, because he never told Jackson his mother was critically ill. Instead, plaintiff alleges that the real reason his supervisors reported his travel to the Office of Security was because of his race, and because a supervisor was biased against Islam and believed it was a violent religion. These allegations, however, are insufficient to defeat defendant's motion for summary judgment.
Wow, that's
assertion that he never told
that's an
that he was
increase
traveling
of
to Afghanistan because his mother was ill is not supported by the record. Moreover, irregardless of the reasons why Jackson initially reported Isker's travel to Brent, her supervisor, defendant has established that it was Bureau policy to report such travel to the Office of Security and that Brent acted pursuant to this policy. Of greater significance, plaintiff does not dispute that Alonso, the decision-maker responsible for launching the security investigation, acted honestly and reasonably when he decided to further investigate Isker. Indeed, Isker does not dispute that Alonso honestly believed Isker was traveling to Afghanistan because his mother was ill and that, upon reviewing Esker's security folder, discovered plaintiff's mother was already deceased. Based on this material discrepancy and the fact that Esker was traveling to a country in which the United States is engaged in armed conflict, Alonso decided to further investigate Esker's travel. To date, plaintiff has presented no evidence to indicate that Alonso was unreasonable in his decision to undertake an investigation under these circumstances, or that he was motivated by anything other than the security interests of the Bureau. Thus, for all these reasons, plaintiff has presented insufficient evidence for a reasonable jury to conclude that the security investigation was undertaken for a discriminatory or retaliatory reason. Accordingly, defendant's motion for summary judgment is granted on plaintiff's discrimination and retaliation claims. Case commentary. The District Court of the District of Columbia ruled that security was a legitimate non-discriminatory justification for its actions and was not motivated by pretext. Case questions. Do you agree with the court's assessment? Do you believe this is a case of ethnic profiling? Did the proximity in time to 9/11 provide additional justification for the Treasury Department's decision?
I
Adam
mean,
Silva
it
versus
didn't
SC,
help.
Catholic School, Wichita, Kansas. 2009 U.S. DIST Lexus 2226, U.S. District Court, Kansas. Case 15.5. The issue is whether the English-only policy was directed at Hispanic students and as such amounted to national origin discrimination. Martin, United States District Judge. This action arises out of an English-only policy implemented at St. Anne's Catholic School, St. Anne's, near the beginning of the 2007 to 2008 school year. At the time the policy was implemented, the three minor plaintiffs, Adam Silva, Dalia Fernandez, and Cesar Cruz, were students at the school. After the policy became effective, the three minor plaintiffs and their parents brought suit, alleging discrimination based on race, color, or national origin because of the English-only rule. St. Anne's is a private Catholic elementary and middle school in Wichita, Kansas, operated by the Catholic Diocese of Wichita. The admission and continued enrollment of a student at St. Anne's is voluntary. The school and the diocese reserve the right to admit or deny admission or continued enrollment to any student at any time. The principal or pastor of St. Anne's is the final authority on all matters related to discipline. The school handbook provides, in part, the principal and/or pastor is the final recourse in all disciplinary situations and may waive any and all regulations for just cause at his or her discretion. When rules aren't followed, consequences will be given depending upon the nature of the offense. All plaintiff families acknowledged that statement and agreed to be governed by the handbook when they enrolled their children at the school. St. Anne's receives federal funds through the National School Lunch Program, NSLP, administered by the United States Department of Agriculture, USDA. Under the program, the government gave St. Anne's $2.47 in cash for every free lunch, $2.07 for every reduced price lunch, and 23 cents for every paid lunch the school served during the 2007 to 2008 school year. The three minor student plaintiffs, Adam Silva, Dalia Fernandez, and Cesar Cruz, speak English and Spanish. English is their primary or first language. Further, plaintiffs in this case are all Hispanic, as that term is generally understood. Early in the school year, several of the St. Anne's staff expressed several behavioral concerns, which they attributed to certain Hispanic students individually and as a group. Several incidents involving the treatment of the Hispanic children were described in detail during the trial. Notably, the children were told not to sit together during lunch. Later, that plan was allegedly revoked, but then confusion ensued when the revocation was deemed a mistake. The Hispanic boys were not told of the mistake prior to the time that Adam Silva was moved from one place to a table by himself during lunch. Additionally, the Hispanic children were told to mingle with other students on the playground. St. Anne's formally implemented an English-only rule near the beginning of the 2007 to 2008 school year. Prior to September 2007, there was no written English-only policy at St. Anne's. The policy essentially required that students were to speak only English at all times during the school day, including during lunch and fresh air time. After the implementation of the rule, several steps were taken by the school and the parents, as detailed in the summary judgment order. Notably, the St. Anne's students were asked to acknowledge in writing that they had been told of the policy. Further, St. Anne's sent a written policy statement home with the students for the parents to read and acknowledge. When asked to sign an acknowledgement of the English-only rule, Adam Silva refused. On October 12, 2007, Adam Silva and his parents had a meeting with Sister Margaret. Sister Margaret contends that she asked the Silvas to transfer Adam to St. Elizabeth and Seton Catholic School due to parental defiance of the principal's authority. The Silvas argue that Adam was expelled. Despite the differing accounts of the events of that day, it is clear that Adam Silva was told to leave St. Anne's, and St. Anne's was helpful in arranging for his transfer to another Catholic school. The inference from the testimony was clear that the Hispanic children were watched more closely than the Caucasian students. This inference is supported by the notes that were admitted into evidence, as well as the testimony of the teachers and staff. Plaintiffs claim that the English-only policy caused other students to taunt the minor plaintiffs. Plaintiffs identify two incidents where another middle school student made a statement or did something they considered inappropriate. One related to an email reflecting hostility toward the Hispanic community.
Yeah, I'm
by
kind of
referencing the
sleepy
United
too. This is
States
just a
as
lot
our
of
country, not yours.
legal
Sister
stuff.
Margaret met with the student and the student's mother to discuss the offensive nature of the email. The student who sent the email was counseled on the inappropriate nature of the email and was told not to do anything like that again. The other incident involved a student telling Dahlia Fernandez not to touch or fold an American flag after Dahlia Fernandez folded a flag and mistakenly forgot to put the stars on the outside. A student told Dahlia Fernandez that she had done it wrong and that we weren't in Mexico. The teacher talked to the student about the comment, corrected the student for his inappropriate comment, and handled the event as a teaching opportunity. Dahlia Fernandez reported that she felt that it was appropriate for her teacher to talk to the boy who had made the comment. Conclusions of law. A contract does exist between St. Anne's and the families of the children who attend St. Anne's. The families agree to contribute a portion of their earnings to the church, and the church agrees to provide the children with an education. Further, there is language in the handbook and in other school documents, as well as federal statute, that is sufficient to establish that St. Anne's has a commitment not to discriminate on the basis of race, ethnicity, or national origin. In peer-to-peer harassment cases, only deliberate indifference to such harassment can be viewed as discrimination by school officials themselves. Deliberate indifference can be found only when the defendant's response to known discrimination is clearly unreasonable in light of the known circumstances. On its face, the policy itself does not create a hostile educational environment because it is neutral in its wording. As such, the remaining question is whether the policy creates a hostile education environment in its operation and effect. To create a hostile environment in its operation and effect, the consequential conduct must be so severe or, if lacking in severity, so pervasive or a combination of the two that it makes it impossible for the affected student to learn. To be pervasive, the instances of harassment must be more than episodic. They must be sufficiently continuous and concerted. Plaintiffs cannot prove that the alleged harassment was pervasive. There is no single incident that is so severe as to create a hostile environment. Further, the events that were testified about did not occur over a long enough time and were not severe enough to create a hostile educational environment. Additionally, St. Anne's was clearly not deliberately indifferent to the incidents of peer-to-peer harassment. Instead, St. Anne's acted quickly to any and all incidents that it knew about regarding inappropriate comments among peers. Because there was not a hostile educational environment, the school need not establish that it had legitimate reasons for implementing the policy. Nevertheless, it appears that the school acted in good faith and felt it had reasons for implementing the policy. The evidence establishes that the school was responding to incidents which would have required action, regardless of the ethnic group involved. With respect to the monitoring of the students, the court finds that the Hispanic students were not excessively
You gotta work
monitored
in the morning,
an intrusive way
hon?
that created a hostile environment. Instead, there is a certain amount of monitoring that is necessary in any school in order to ensure that students are complying with the school's directives. In sum, the request for injunctive relief is denied with respect to St. Anne's English-only policy because it is objective neutral. Further, the policy did not and does not create a hostile educational environment. No incident or combination of incidents was severe enough to create a hostile environment. Accordingly, judgment shall be entered in favor of the defendants. Case commentary. The U.S. District Court of Kansas ruled that St. Anne's English-only policy and its treatment of the Hispanic students did not create a hostile education environment for them. Case questions. Are you in agreement with the court's decision? Do you believe that St. Anne's English-only policy was in the best interests of its staff and students? Is it the prerogative of employers to institute an English-only policy, or must they justify the reason for it? Luis Angel Perez v. The New York and Presbyterian Hospital. 2009 U.S. CIST Lexus 102139. Southern District Court, New York. Case 15.6. The issue is whether the hospital's policy requiring its staff to speak to each other in English only is in violation of Title VII. Sand J. Luis Angel Perez, plaintiff, brings this action against the New York and Presbyterian Hospital, defendant, or the hospital, seeking money damages for the hospital's alleged violation of Title VII of the Civil Rights Act of 1964. Plaintiff alleges that the hospital discriminated against him based on his race and national origin, created a hostile work environment, and retaliated against him for complaining of Title VII violations. We grant the hospital's motion for summary judgment on all claims. Plaintiff is a bilingual English/Spanish-speaking Hispanic male of Puerto Rican descent and holds a bachelor's degree in psychology from the City University of New York, which he earned in 1996. The hospital hired plaintiff on July 29, 2002, as a mental health worker, MHW, assigned to the inpatient psychiatric unit at the hospital's Allen Pavilion campus, psychiatric unit. The patients in the psychiatric unit are approximately 50% bilingual English/Spanish-speaking Hispanics and 30% monolingual Spanish-speaking Hispanics. The physician in charge of psychiatric care, Lord Dominguez, MD, and the assistant chief, Giovanni Nunez, MD, are of Hispanic national origin. Being a bilingual English/Spanish speaker is a job hiring preference for MHWs. Hospital policy, as set by medical staff at the psychiatric unit, requires all communications in the vicinity of patients to be in English unless otherwise directed. The hospital's proffered rationale for this policy is to avoid splitting, a situation in which a patient hears two different languages and refuses to cooperate with English-speaking nurses and doctors, thereby undermining treatment. The hospital maintains that it does not have an English-only policy. Plaintiff was frequently required to translate for and speak to Spanish-speaking
All right, let's go get a sword.
patients who had no proficiency in English. Plaintiff alleges that he was thrust into a hostile work environment and relentlessly reprimanded for speaking Spanish to coworkers and patients. He alleges that his nursing supervisors frequently used ethnic slurs and engaged in conduct denigrating him because of his national origin, including mocking patients with limited English proficiency, mocking the Spanish language, demeaning him for speaking Spanish to patients, and referring to Hispanic individuals as those people. Plaintiff also alleges that he overheard several statements made by supervisors encouraging black employees not to fraternize with Hispanic employees or patients. On August 15, 2003, Dr. Nunez came upon a crisis situation in which a number of hospital employees were attempting to medicate a hostile patient. When Dr. Nunez entered the room, she observed plaintiff speaking Spanish to the patient while a nurse simultaneously spoke English to the patient. Dr. Nunez counseled plaintiff not to speak Spanish to a patient unless instructed to do so by a physician. Plaintiff wrote a letter to Dr. Nunez the same day explaining that he was speaking Spanish in an attempt to convince the bilingual patient to drink his medication voluntarily rather than be restrained and receive an injection. In the letter, plaintiff stated that he disagreed with the anti-splitting argument, as explained to him that day by Dr. Nunez and two nurses, because he believed it was more effective to communicate in the patient's native language in a crisis situation. Plaintiff stated that he always directed the patients to obey the English-speaking staff when he spoke to them in Spanish. On August 26, 2003, plaintiff received a final written warning from nurse manager Dorette Johnson for the August 15, 2003 incident. The warning then threatened plaintiff with termination if he ever worked outside the scope of his job responsibilities in the future. Plaintiff alleges that there had been no prior written warnings or reprimands issued to him. On May 17, 2004, plaintiff was reprimanded by nurse manager Doris Birch for speaking Spanish to a patient, and a formal problem report was written. On May 24, 2004, plaintiff was given a last final written warning for failing to work within the scope of his job responsibilities and sending out the May 2004 report. The memorandum ended by threatening him with termination for any further violations. Plaintiff was reprimanded again for speaking Spanish by a nurse on June 19, 2004. Soon afterwards, plaintiff requested time off due to distress, but was ignored. On August 9, 2004, he became ill with vertigo and took time off work for his illness. He did not return to work until August 28, 2004. On September 1, 2004, plaintiff was banished from work until he could obtain medical clearance to resume work. He resumed work on September 3, 2004. On August 30, 2004, plaintiff filed a complaint with the Equal Employment Opportunity Commission, EOC. The charge alleged that the majority of non-Spanish-speaking employees in this hospital, including administrators, incessantly oppressed Spanish-speaking patients and staff, that this treatment was inhuman and abusive, and that he and his family suffered, physically, psychologically, emotionally, and spiritually. Plaintiff's EOC charge merely alleges that the majority of the non-Spanish-speaking employees in this hospital, including administrators, incessantly oppress Spanish-speaking patients and staff, that this is inhuman and abusive, and that he and his family suffered physically, psychologically, emotionally, and spiritually. Other than these conclusory assertions, the charge only mentions several discrete instances of discipline, and is devoid of any reference to racist jokes or pervasive and frequent treatment causing humiliation and rising above the level of mere fact. Rather, the allegations in the EOC charge relate solely to several discrete instances of alleged discrimination or retaliation, which are insufficient to exhaust the hostile work environment claim. A. As regards non-work-related conversations in Spanish, the hospital claims that it does not have a blanket English-only policy. While courts have been more leery of blanket English-only policies that encompass even non-work-related conversations, plaintiff has not put forward sufficient evidence to conclude that he was in fact reprimanded for non-work-related Spanish conversations. Plaintiff claims that Ana Larios, a clerk, will testify that she was scolded for speaking Spanish in the office, away from the patients, and that Mr. Williams, a security guard, was screamed at a couple of times for speaking Spanish on the unit. Plaintiff also claims that he was scolded for having a conversation in Spanish with security guard Julio Morejo sometime during September 2004. But plaintiff has not provided affidavits from any of the aforementioned individuals. Given that plaintiff has put forward nothing more than his own allegations, and given that so many other instances of discipline admittedly occurred during this time period for speaking Spanish to patients, plaintiff has not put forward sufficient evidence to raise a genuine issue of material fact as to whether he was disciplined for non-work-related Spanish conversation. As regards the hospital's anti-splitting policy, plaintiff has not put forward sufficient evidence to show that the hospital's proffered reason was false and that discrimination motivated the enforcement of the policy. The hospital's policy prohibits Spanish conversations in the vicinity of patients because the medical staff has determined it is in the patient's best interest. The rationale is based on avoiding splitting, where patients refuse to obey English-speaking staff after being spoken to in Spanish. However, plaintiff was frequently asked to translate by hospital medical staff, and being English/Spanish bilingual was a MHW hiring preference. While a speak English instruction may form the basis for an inference of national origin discrimination if supported by other evidence, courts have upheld limited English-only policies against Title VII challenges when supported by valid business justification. Additionally, courts have been especially leery of finding a limited English-only policy's proffered justification to be a pretext when applied to a bilingual employee, such as plaintiff, who is capable of communicating while not violating the policy. Furthermore, courts have found that the fact that an employee has been asked or required to speak Spanish on the job undercuts any inference of discrimination when evaluating a limited English-only policy. Here, plaintiff quite frequently was asked to speak Spanish with monolingual Spanish-speaking patients. Accordingly, the court grants summary judgment to defendants on all disparate treatment claims based on race and national origin. Case commentary. The Southern District Court of New York decided the medical staff policy was in the best interests of the patients. Case questions. Do you agree with the court's decision? Was there any harm in Perez occasionally speaking Spanish? Does the First Amendment's freedom of speech guarantee offer Perez any protection? Summary. The United States, long referred to as a melting pot, is probably the most integrated country in the world. The country derives its strength from the attributes of a population diverse in cultures and traditions. Excluding individuals because of their national origin goes against the grain of U.S. heritage. Individuals should be judged only on the basis of their merit. That being said, inclusive attitudes have not always prevailed, and most immigrants have taken their lumps upon entering this country. 100 years ago, the Irish and Germans were not well received. 75 years ago, the Italians and Poles were resented. 25 years ago, the Spanish and Latin Americans were not wanted. Today, Indians and
Very
Asians
weird
are
to hear
often
them
looked
say
on with
the
disdain.
Poles.
Many U.S. citizens want immigration laws tightened to the point of restricting most non-white immigrants. What these citizens are forgetting is the work ethic that their ancestors brought with them in building the infrastructure that exists today. Most immigrants are not freeloaders. Rather, they are people seeking opportunities to put their talents to work to build a future for their families and themselves, a goal that everyone should encourage. Immigrants are often used for performing the routine ministerial tasks that U.S. citizens refuse to do. Hard labor, landscaping, assembly line factory work, janitorial maintenance, and gas pumping are a few occupations serviced by a significant number of immigrants. From another perspective, as immigrants mesh themselves into our society and have children, those children will eventually compete with current citizens for better paying positions. There is another facet of immigration that must be taken into account. As the population grows, pollution and garbage increase proportionally. Development causes overuse of the land, natural resources, and water. Erosion occurs. Disease proliferates, and quality of life deteriorates. In the areas of technology, communications, and product development, our innovation is unparalleled. But in purifying our air, water, and food supply, we are underachievers. Therefore, the number of people that can adequately be supported by the vital resources of the United States is an issue to be seriously considered. This problem pertains to the number of immigrants in the future. The United States should embrace those immigrants already here into our society and encourage them to utilize their talents to their greatest potential for the benefit of all. Discrimination against immigrants serves no purpose because they rarely leave involuntarily. It serves only to delay their inevitable amalgamation into employment and society. Thoughtful planning with regard to supporting future immigrants with the vital resources available to current citizens is an intelligent policy, but purposeful discrimination against immigrants already in the country is not. Immigrants should be treated as equals. Human resource advice. Treat all applicants and employees the same regardless of their national origin. Know what employment rights are given to resident aliens. Guard against employing illegal aliens. Learn what documentation is required before hiring aliens. Do not advocate or tolerate ethnic harassment in the workplace. Understand that a person's surname, spouse's national origin, and affiliation with an ethnic school or association should not be considered in any employment decision. Develop an expertise in IRCA.
What are you doing?
Appreciate why the Civil Rights Act includes national origin as a protected class.
That space is
Refrain
strictly
from
out of
asking
bounds.
candidates for
Arnie,
employment
come
in
back.
which
You
country they
can't
were
just
born.
override the map.
Recognize that Title VII
That is
and
cheating.
IRCA do not apply to
Well,
U.S. citizens working outside the
Two
United
can play
States.
at that game. You've been
Well, that's the end of the chapter. Let's go fight a dragon.
Morgana invokes diabolical powers to defeat her nemesis, Sir Arn. Dread powers that warp
Not
and
usually run with
change her
healing
vi-
kits.
The evil Morgana has become a dragon. Her fiery breath is death.
This is crazy that this is in this game.
Form an impenetrable armor. Can Sir Arn find a weak spot on this seemingly invincible foe? Morgana summons her minions to join the fight.
Why don't use guns?
Morgana roars in pain and rage. Your attacks have weakened her.
Oh my god.
Vanquished the evil that is Morgana. The way to the sorceress's treasure vault lies open before you.
Oh, I guess I already got that. Ha.
I'm sorry, Arnie. Someone's... Remember? I should have calculated this right away. Away? Well, I am...
Here we go. We got another copy of the sword. I think I got quite a few of these now. Well, I guess I can close my my homework and my books and everything. All right, let's get out of here, huh? I have the volume on this turned down so low. I literally just came over here to pick up another copy of the sword. I don't need anything else. That was a lot. Like, there's so much, like, reading that we have to do and get through every single week.
Entered desert botanical testing.
I don't even know what time it is. Oh, we're only halfway up. So we've got our base mostly rebuilt. Actually, I take it back. We have our base rebuilt. We have our stuff. Everything's just coming back together. I thought I was only gone for like a week, but apparently I was gone for longer because we lost power and my ship got destroyed. So just picking up some stuff. Yeah. Damn Sardaukar. Got a decent amount of work here I do tomorrow. I don't think I have any fuel on me at the moment, do I? Yeah, I do. Let's see what we got going on here. Hey, Dory. How are you doing tonight? Yeah, I feel that. I definitely feel that. Mm. Oh man, we have another week coming here. Another week coming up. I gotta plan my trip home. I've got to talk to my boss about it tomorrow. Stupid Sardaukar. I typically make a trip home in October. Yeah, I typically make a trip home in October. So I have to figure it out for next month, which is Wednesday, apparently. Yeah, October's here. Like what? I only have one of these. Really? I thought I had more. I thought I had learned more. Well, I got plenty of spark swords, and I have plenty of Sword of Seven Sorrows. So that's feeling pretty good. There should be a bunch of aluminum. Sure, I guess 170 is a bunch of aluminum. I don't even know anymore. I have to go mine Jasmine. I have to go do that. That's fine. Am I out of blood? I know I'm pumping a body out, which is almost completed. Yeah, I don't have a lot in this circuit. Oh, this has got like 20 minutes left. Jeez, never mind. I thought that was going to be done quicker than that. How goes my air? Eesh. Crap. That's fine. I need bodies to wrap up anyways. This is generic person. This game exists in like an alternate universe where he specifically says, I was never born. My mother became this. So this is very much an alternate story of it. The Atreides were never
A large sandstorm is approaching.
the Atreides were never betrayed. So like his dad is still alive. His sister is somewhere. All of the Freemen have been wiped out. Yeah, I actually really appreciate where they went with the story to so you're not playing, you know. Where's the other body at? Oh, there it is. To make it kind of like to give you the chance and other people to have a kind of like a unique Dune adventure.
Sector weather alert. A large sandstorm is approaching.
Oh, the storms here. Yeah, I got a very weird base design for storms because I kind of have more of an open floor design. It is like I was like, how are you gonna run around the Dune world? And then, I mean, if you want, like the whole opening movie here, exit to main menu, confirm. Honest to God, it set itself up amazing. It really did. It was really an amazing setup for this. Oh, I have to exit the game and come back in, don't I? No, this will replay. No, it won't. Yeah, there we go. I've just listened. How long have I been streaming? I've just listened to 2.5 hours of legal lawyer like stuff. Like my brain is kind of just numb at the moment. It was like we went over sex discrimination, religious discrimination. I went over sex discrimination earlier today, and I was just like, most of this is wrong because like all the law has been changed now. In 2020, a lot of Title VII of the Civil Rights Act now includes everything that the book said it didn't. So I'm like, well, that's kind of made the book worthless. Oh, hope you don't like flashes. Unreal Engine. Funcom. I hate that it checks shaders every time because that just means I can't use my whatchamacallit. Here you go.
I dream of it amongst the wild threads of history and the myriad of paths. My path saw the Imperium rise from the ashes left in the wake of the Great Revolt. Thou shalt not make a machine in the likeness of the human mind. With that commandment, new avenues of human potential were explored. Mentats, Suk Doctors, Sword Masters, and the mystical Bene Gesserit Sisterhood. But it was the Navigators and their monopoly on space travel that set the conditions for the Imperium. But I am telling you of the universe you already know. Let me describe the one you do not. In this other universe, my mother, Lady Jessica, consort to Duke Leto Atreides, gave birth to a daughter, a girl they named Ariste. Because of her obedience to the Bene Gesserit, Lady Jessica is trained as a truth-sayer. Because of that training, Lady Jessica was able to detect Dr. Yue's deception. Because of the forewarning of his betrayal, House Atreides survived the Battle of Arrakeen. Because of their survival, the Emperor declared a full-scale war of assassins. Because of the war, the Sardaukar were deployed to ensure spice shipments continued without interruption.
I hate the
Because
Sardaukar.
of the Sardaukar, the Fremen were eradicated. There was no Muad'Dib, no Lisan al-Gaib, no Kwisatz Haderach. I see a universe where I, Paul Atreides, was never born. All my visions lead to horror, except this one. This one leads to you.
And I was like, okay. Okay. That sold me on the story. I'm like, all right, let's do it. I can buy into this. I'm very well aware of spice and what it does. It's an amazing premise. It's just like, okay. Paul's not born? Let's go. So like one of the first things that happens when you get on the planet is it's like, oh, the Fremen are gone. Like see if you can hunt them down, find out where the remains are and stuff. I mean, yeah, it seems dark, but it very much is the story of the Sardaukar, you know? Like it is, I don't know how to say it is what it is, but it is what it is, you know? What time is it? It's almost 9 o'clock. I was thinking of switching over to Final Fantasy, but that's not going to happen. So there's like no Fremen, but you have to like find out what happened to them and where they are and stuff like that, and I've got to go get a bunch of delirium Dura aluminum ingots. I have barely any now. The thing that sucks about Dura aluminum is it takes like all of your water. So for every one piece of aluminum ingot, okay, to get aluminum ingot, 7-to-1 ore to ingot ratio. That's iron. Yeah, and I was gone for a little bit too long, so my base lost power. So like I've literally spent the past 2.5 hours besides like listening to my textbook, like just trying to get my airship back. And now I have no idea what I want to do. I'm just, I'm kind of like, okay, now what? I mean, realistically, I have, I still have 13 skill points left. Ugh. can hear the worm outside. Let me get some water. This body should be finished, right? 10 minutes? Ugh. Fill container. Drink. I like how the body shows up more when it's close to being empty. That's a really nice touch. All right, let me see what mission we have here. I mean, technically I have a story mission I have to do, right? Oh, I have to go to the Atreides base. Oh, we'll go to the Atreides base. That's fine. That's fine. We'll go to the Atreides base. We like the Atreides. My entire everything is based off of their stuff. Click. Click. There we go. Very Atreides base right here. Look at that. Let's go turn in our contracts. They're not quests. Really need to look to see if there's any more spice fields, which there is. Now this shouldn't be on, yeah, worm sand. It's not. Yes, I know. We have severe sand poisoning, sun poisoning right now. It's fine. We have plenty of water on us. Why isn't the worm coming? Am I really? Oh, there it is. Wow. Alright, worm's gone. It's funny because I have a ton of spice, I just don't do anything with it. think I could probably get one more before it comes again. Yep, there it is. There it is. Might be able to get two more? Oh, there's nothing really here, is there? Yeah, there's nothing much here. I don't remember what I was doing. Oh, I was riding around. I was being stupid. That's what it was. And it was even on stream. Like, I was just messing around and like, oh, I've summoned the worm. I'm just going to blitz across the sand still and not pay attention to it. And I turn around and look, and it just dove right as I hit solid ground. Yeah, the rest of that's not really worth getting, so we're good. Any other spice melange anywhere? Well, that's not spice melange. I have to convert it to spice melange, and it takes forever to convert it into, like, usable spice. Unfortunately, you have to look with the right or with the mouse, because if you try to do it with the right stick, even though it'll say hold down right stick to look, the ship automatically goes to kind of where that dot's pointing at. So, all right, looks like there's no more spice or whatever in the area. So, you can go to the Atreides house quickly. Oh, now that would be a cool design. Oh, a little like runway thing. That's so smart. I might do that. I might try to do that. Oh, that's really clever to use that as like a landing pad thing. Yeah, I would never be that smart.
The balance of probability suggested I'm good. I have the test results of the tainted spice. It will take time to interpret the data, but we will have a better understanding of this poison. What did Thufir say regarding my request to eliminate Ambrose Lucifera? What? No. No, his is a brilliant mind. Surely he understands the logic, the calculation, the need. Lucifera is a corruption, a cancer. The only kindness is to cut him out. The only solution to the equation is terminal. Why doesn't he compute that? And what if that's true? I have a mind of meat and electricity like anyone else. I just have to think, to collate. Thufir is rarely wrong, but he is wrong now. We must act before it is too late. We will take the initiative, and I will take full responsibility. On the surface, Ambrose Lucifera appears to be a wealthy, if inconsequential, reveler. But he's had a hand in many hidden deals related to the war.
You never want to be considered inconsequential.
He has covert ties to the Harkonnen. He is involved with the tainted spice. I know he is. People I know have died because we failed to act quickly. I cannot allow this to continue. We must strike before Ambrose is beyond our grasp. Hesitation is not an option. I've taken the liberty of lacing this expensive bottle of wine with some of the tainted spice. It will be undetectable to poison snoopers. Ambrose is a known Epicurean and experience seeker. Convince him that this bottle of wine is a singular and exclusive experience. I'm too well known in Arakeen, but you can make sure Ambrose drinks this. Take the bottle. Say no more. I know you'll do the right thing.
I would love to wear the Bene Gesserit armor, but unfortunately, it means I don't have my
Again, you
still
brighten
suit.
my immediate vicinity.
Welcome back. What can I...
Oh, this is what I spent all my money on, was getting the Atreides stuff. That's right. That's right. That's right. Oh, because devices don't activate. Forgot about that.
In the name of the Red Duke, how can I be of service today? Excellent! Every little bit of help matters, but the Landsrad is a large organization. Do you know which block the recipient belongs to? Ah, the Manufacturing Union. Very good. Delivery for House Alexan. Noted. We'll make sure it reaches them.
Wait a minute. Is that how I get rid of that? Nope.
In the name of the Red Duke.
I was kind of hoping... I don't know. I have no idea what I was hoping right there. We've got to go back to my base to get rid of... Wait. Oh, yeah, we got to go to Rakeen. That's right. Alright, we'll go to the base, we'll drop off the sand. We'll drop off the spice. That looks like a trap, right? Trying to make sure we're still flying at a regularly level pace here. Dor, what do you got going on this week? Anything special? Sardi car flying around. It's trying to stay afloat. Yeah. Oh yeah, that's right. It takes 750 water. Take it back. We won't turn it on just yet. Oh, I think I gotta turn off this thing. Yep. Body's out of it, so we're good to go. We can turn it off for now. That'll give us a little more head space on our power consumption. I'm only gonna get 22 out of it. That's crazy. How long does it take to go from 100 spice to... Okay, so it's 46 seconds per pop. That's fine. Kind of want to go vampire some people real quick. Just because it's fast. Yeah, I think I'm gonna go vampire some people real fast.
Someone's here.
Yeah, someone's here, I know. Alright, let's go grab a couple more people.
Shield on. Reload.
He fell into the fire. Alright, let's go turn in that really quick. Look at that turning into some water. I feel like I should be able to get a couple more.
I see someone.
No, you don't.
Shields up.
Who's there? Someone here. I require assistance.
No, I'm taking their blood. No, you take their blood, you put it in the little blood pouches, these things, and then you run it into the water or the blood purifiers, which pulls water out of it. So then all the water in these two machines goes into my water canisters right here. And that's how we keep our water in this game. All right, so now, okay, so that seemed, but yes, for water, yes. All right, so we're gonna fly to Arakeen, because we're House Atreides. That's our boys. So we're gonna go to Arakeen, and get somebody to die, I guess. Oh, there's one of the worms. Living his best little life over there. Hey, Gengar, what's going on, man? Wait, are you back? Thank you for the resub, my dude. 18. My lord. Welcome back, sir. Kind of. You're kind of back. Okay. I love crashing into the loading wall because the game doesn't know what to do at that point. Like, you just kind of like, meh, as you saw there for a second. The schedule's really messed up? Why is it messed up? Alright, let's go to Arakeen. God, a bug got me really good on my neck right here. I like this little welt. I don't think Kitty's playing today, is she? Dude, I'm not even gonna lie. It took me a second. I'm like, wait a minute. President's not coming here. And I forgot you don't live anywhere near me. Not anywhere near me. Oh, it's Monday to Thursday. That's what it is. Okay. No one's on the same page. Why would anybody be on the same page? Gengar, I love you. Don't be stupid. Why would anybody be on the same page? Exactly.
I can already tell we are going to be fast friends, unless we already are, in which case it's so good to see you. How long has it been? Well, far be it from me to look a mysterious wine-bearer in the mouth, but perhaps you ought to tell me who your patron is before I accept. That does sound romantic. When do I get to meet her? Or him? Caledonian wine. A rare
experience.
By Jove, I like you. I'm going to a party later, and sharing this will make me the belle of the ball. Do you drink while on duty? Don't answer. Let me tempt you not. I'll shield you from this devil's ambrosia. Just a selfless soul, drinking for two. Well, I'm afraid something of this vintage simply must be shared. It's just my indelibly magnanimous nature.
Oh, wow. I was thinking to myself, I'm like, you know what? Like, I was planning on telling him, don't drink the wine, it's poison, you know?
Beg your pardon? You really are bizarre, and such awkward, weirdly timed, and self-destructive honesty. You serve the Duke, don't you? Don't answer. Act casual. Clearly the signal in this chain of command has gotten twisted. Go talk to Thufir. He'll sort this out for you. I can't say any more here. I'd appreciate no further murder attempts. I want to like you, but I have this puerile habit of loathing people who try to kill me. It's a quirk of mine.
Of course, I can't, you know, use my Benny sprint.
I expected you. Sorry. Occupational hazard. Ah, I hadn't expected her to move so fast. Know that you did the right thing and showed excellent judgment. Andrea turned herself in, claimed complete responsibility for everything. Loyalty still means something to her, and a willingness to face consequences. Her actions took me aback. Ambrose, you see, was my double agent, feeding misinformation to the Harkonnen. There will be a disciplinary action. Then I will place her on other cases far from Skorda. She faced her misconduct with honor. Our work isn't done. Now you work for me directly. You have Andrea to thank for that. She made the case to keep you on. She made it very well. A process cannot be understood by stopping it. Understanding must move with the flow of the process, must join it and flow with it. I can only teach you what comes next by throwing you into the flow directly. Perhaps, in the process, we can save my Duke and his house. Understanding the origin of the tainted spice is vital. Taking in all of the data, I detect Imperial influence. Though I do not know from whom. We must trace the links in the chain back to Skorda. It is from him we will get clearer answers. The man recently appeared in Erekine. I've calculated his most likely contact, a naive Atreides trooper named Rafe Arslau. He's stationed in Erekine. Find him. Find out what he knows. We know he's had past dealings with Skorda. Further details are in the contract.
Okay. Looks like we're continuing on with our little... I wonder what happens if you, level 156, great. I wonder what happens if you actually do kill the thing, or kill the guy, I guess. Back to the bar, just like most D&D adventures. The leveling in this game seems weird because I just level up so quickly doing nothing.
Hi, is there something you need? You are you? Well, who's asking?
Part of his crew.
Yeah, I heard he got jumped by mercenaries when he tried to go off-world. Happy to help. Skorda's a hero of mine. I owe everything I am today to him. I was just a street dog on Caladan. I messed up.
Yeah, I'm going to be winding down here
I was on my
shortly,
way to
too.
a prison planet. But Skorda, see, he was in the constabulary. He saw something in me. Skorda covered it up for me. Got me set up as a recruit in the Atreides house forces. And here I am now.
Dory, have a good night. I love you. I'll let you know
Last
when I'm
I
coming
saw,
home next.
Skorda was talking to one of them weirdo cult recruiters in town. I gotta see one of them.
Gengar, good. Yeah. I really hope in patches they start repairing the city, or at least within your story in the city.
I expected you. Sorry. Occupational hazard. Well done. The cult in question is the Masquerade. Strange cult. Even stranger rituals. But why would Skorda be talking to them? Speak with one of their cult recruiters. See how far you can get by playing an eager new recruit. Their practices may seem strange and even nonsensical, but don't fall into the trap of underestimating them. It's a bad
habit. Am I just hanging out in the I guess I am. Wow. I'm not used to being in the main city for so long. I feel like I contributed a lot, because it's always like, oh, this, and this. I have no idea how the Lanzarad works. Not even gonna try to fake it. No idea. Oh, I remember this person. Yeah.
Shai-Hulud blesses me with your presence again.
Aw, thanks.
And the coils of providence bring you to us. I am a Naib of the Masquerade. I am a teacher. I am a recruiter. We follow the holy tremis of Shai-Hulud, as interpreted by our Sayadina Nala. We honor the tyrant worm by spilling our water. I understand your confusion. To the blind, sight must seem like insanity. But this is blindness that can be cured. In the meantime, can I be of help? Oh yes, a promising convert. Come to our learning center in the Udum. You will find your friend, and perhaps enlightenment.
This is worse than fetch quests. This is back and forth quests. Man, I'm really glad I didn't have an assault ornithopter. Gengar, I don't know if you're still there, man, but if you get a chance, the bases have all pretty much been hit. I don't know what happened. Like, all my stuff was wrecked.
I expected you. Sorry. Occupational hazard. An impressive performance and a tidy report. I appreciate that. So many field agents are sloppy with their documentation. I'm afraid there is no time to build a proper cover. Besides, I already have a hidden agent among the Masquerade. You'll do what you do best. Attack swiftly and directly, and obtain what information you can. It seems we're not the only ones after Skorda.
Yeah, dude, like, my base was wrecked. I lost my ornithopter. Araya's base was pretty destroyed. Sariel's base is pretty wrecked. I didn't get a chance to go look at yours yet. Yeah, no, I get it. I took like a week off because I was focusing on school and Final Fantasy.
I received word that he tried to get off-world before
but like I lost power.
Oslo, but was attacked by 2 mercenaries. He made a daring escape. Perhaps Harkonnen, perhaps someone else. Skorda may have joined the cult for strange purposes, but I wager he wanted protection from his attackers. Go to the learning center. Find Skorda or information leading to him. Take all due precaution.
So I take it that I have to go back to Haga. Got it. Okay. Back to Haga Basin. That's so cool. Connecting to a world map. Let's go. Back to the basin. I'm very happy we don't have issues right here. So settings. Every time we go between maps, we have to reset this because it changes my drinking commands. There we go. Oh, that's one of the houses. I don't care about that. Well, Gengar, I guess I can actually take a quick run to your base and head in that direction. I said I'm gonna head to your base real quick, see what's going on with it. It's gone? No, it's not. No, see, yeah, your stuff is still here. See, you're still here. Wow, your base is in a lot better condition than Araya's was. I'm not surprised because yours is super shielded. I mean, you have some wear and tear, like right over here. You can see it. But like overall, this isn't bad. Yeah, overall, man, everything's holding together pretty good here. Good job. Oh, I love your ramps. This is Gengar, you're so good at designing stuff, man. I should pay you to do mine. Oh, that's right. We have to go over that. Okay, I think I came down a little too hard on this. Wait, it's up there? Alright, looks like we need a wristband to get into the club. Yep. I went the wrong way. I've accidentally cleared out this place before, too. Through exploring. I've done so much just by exploring accidentally. I have this sword on accident. I love this sword so much. Such a good sword. Such a good sword! They take damage when I block them. Oh yeah, they absolutely changed how that stuff works. They also increase enemy accuracy. Then I'll get 100% accuracy after, I think, 3 seconds. Yeah, so that sucks. So you kind of got to be a little bit more squirrely with how you're attacking. Wait, is that where I came in? Was that the door? I thought I came in through a side door. Unless I'm mistaken. Wait, this is where I got the key from.
This latest group of pilgrims includes many promising initiates. Truly many see the hand of God in the green growing things that flourish in the Udam. Those who show less zeal have regrettably been turned over to the adepts for more rigorous instruction. In particular, one recently recruited brother professed appropriate devotion and revealed to us his past as a house trooper. When tested, he demonstrated superior fighting skills and indicated that he could be of use training our militant adepts. I'm certain Shai Halud has led this righteous warrior to us for the good of the faith. I sent him on to the testing station to report to Naib Jorba.
Yeah, we just gotta back out and go to the testing station. That'll be easy. I just want a big circle. Wait, is this the testing station I always go to? Wait, what? It is. That's fine. So this is the testing station where you fight the dragon to get the sword. The sword that I have. I don't think I need to do that dragon part. Because I think this is just the station. Yeah, I'm using a sword called Seven Sorrows. I've picked up 2 copies of it. Damn it, I don't want to activate that. Whatever, it's fine. It's fine, it's fine, it's fine, it's fine, it's fine.
Shields up!
Yeah, I need to find some healing kits. Por favor. Oh. I don't need more money. Like, I really appreciate you all just giving me all your money. I don't need any more money. Alright, so yeah, we still gotta go down.
Starting to get fouled. You need backup!
So the dragon fight is through here. It's down here at the loading wall. But as far as I know, I don't. Yeah, it's on this level, so I don't actually have to do that. It's part of the DLC that they came out with. Like I said, I found it by accident, actually. How'd that work out for you? I guess I should start picking up this so I can make some more bandages, right? Like... Ooh, I only have 183 light... Really? Only 183 light darts, huh? Well, might as well go back and pick up people's, I don't want heavy darts. I don't have a heavy dart gun. Drop. Ow, 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 ow. I just kind of put together I should probably be picking up light darts. I used to have 1,000. Now I only have 200. Stop shooting people with poison. Okay, again, heavy darts, heavy darts. I don't want heavy darts, I want light darts.
Anil, imprint the following message in your bird and send it to the Sayadina at once. Revered Sayadina, we discovered one of the ancient testing stations brimming with water and occupied by scavengers. We have taken their water for Shai Hulud. I ask for your command regarding this sacred bounty. Naib Jorba.
Wait, I think I have to go get a key, right? Yeah, I gotta get the key up here. That's right.
Naib, the bird has returned bearing this message from the Sayadina.
Jorba, Shai Hulud truly honors us. First with our victory at Maisa Turin, and now these rich spoils you have taken. Our blind brethren of the Ikhwan Bedouin would hoard that water for themselves. Such greed angers Shai Hulud. Small wonder they have fled away in shame. But we, the faithful, remain to serve the Maker in all things. What you have won will be his in good time. But more scavengers are certain to come seeking our prize. Remain, and take their water as well. Nala.
Oh yeah, this is where you have your chest. But there's people here, which is a first.
God, we are one.
Doesn't look like I'm feeding your god today.
Jorba, I received your message regarding our ailing and absent brother. You say you found the name Skorda amid his abandoned personal effects. I wonder why he chose to hide it from us. It saddens me that he has fled from his holy duty to train our militant adepts. But if he has grown as ill as you say, then he is a threat to us all. I want no sickness near my person. Is not my personal health and well-being vital to the faith? No doubt he has learned of this commandment and fled to save his life. A sad breach of faith. Take your adepts and hunt him down. One of our watchers saw him fleeing to the northwest. He cannot have gotten far in such a state. Find him, kill him, and burn the remains. Do not risk close contact.
Oh, because everybody... Yeah, okay, gotcha. Go through here, we get the thing. I think, yep, there's the exit. There's the exit.
You've entered Desert Botanical Testing Station number 163. I'm Dr. Wen.
I mean, no, I don't need another sword. We're fine. We don't need another sword. We have 2 copies of the sword if I need them. Do you want to see what the new dungeon looks like? Here, we'll find out real quick if I can even get a sword. It's a very interesting direction that they took it in. So I was like, okay, it seems like it's like, oh, join this. Like, interesting. Let me see what happens. All right, looks like we can. So, you see how it says on the left-hand side, square to drink? The only way I can get that to change is if I hit it with changing my settings, but I actually don't need to do that right now. I just need to activate the dungeon. Hold on a second.
I can't believe it. The project has been shut down. I've been ordered to...
Accessing the Paladin 9200 passcode. Are you kidding me? I knew you could. Biological
thinking machine. He's a friend. He's my best friend. This has to be a mistake. I've already dismissed the rest of the staff, and I'm gonna go
Simulation.
and get them to change
Initiating. When last we left the valiant Sir Arn, he crept through the fetid and labyrinthian sewers in order to stealthily infiltrate the fortress of the evil sorceress Morgana from below. But even this way was guarded. Sir Arn sees sinister assassins springing forth from the deadly shadows. Defend yourself!
Eyes on target.
Sir Arn is victorious. The way forward is now clear.
Who's that? Here! I see enemy found! Identify yourself! Eyes on enemy! Someone's here!
You did well, Arnie. But your choice of weapons was a little unorthodox. Why didn't you wield the Sword of Seven Sorrows? And what about your spells? Don't forget those.
Yeah, I don't know what he's talking about with the whole spells thing, but I am using the sword.
Someone here! Bouncer! Identify eyes on hostile! Where's the backup? Got them.
Oh my god, did I really just pick up a digital corpse?
Arnie, you're not playing correctly. Please do your best to
I
remain
did.
within the rules and idiom of our game.
That's so funny. I turned the digital guy into a corpse.
Congratulations on successfully infiltrating the castle. Sir Arn finds himself within its formidable walls. Before him lies the courtyard, and beyond that, the entrance to Morgana's keep.
Identify yourself.
Well, without even the slightest attempt at stealth, Sir Arn strides boldly into the courtyard. The guards spot him immediately.
I really wish this game had a better stealth mechanic.
Morgana sends more guards to intercept you. What's more, she casts a shielding spell upon them.
I learned a while ago.
Using spells and equipment that Sir Arn does not have access to. You're breaking the established rules, Arnie.
I learned a while ago that because they don't have a shield, I can literally just swing.
Changes of my own. With the last Guardian laying defeated before him, Sir Arn finds the way is clear to enter the keep.
It's also a really easy dungeon. It's kind of if you play it correctly, it's a great dungeon to just re-up your inventory onto. Oh, I'm already full health. Okay.
You discover a cache of restorative potions. No doubt these will prove useful in the trials ahead. You enter the opulent Great Hall of the castle.
All right, this part's hard.
Here's quiet. But wait! You've been detected. Morgana has summoned her elite guards, and they are armed with, missile wands.
The game's tweaking up because I'm using my controller to move my mouse to aim. I actually don't know where I got this gun from, but I really like it.
Soundly defeated the elite guard. The way is now clear to Morgana herself. But beware! The Grand Sorceress is sure to have a surprise in store for you.
All right, what we got here? I'm gonna do this.
Arnie, it was a lot more fun when you played the role properly. It's not just about winning and losing, you know. We are trying to tell a collaborative story here, remember?
So the Paladin system is shaping up to be a great success. Pal's ability to react to the trainees' tactics, no matter how unpredictable, is nothing short of amazing. Teaching him by playing strategy games together was a stroke of genius. One side effect is Pal's appetite for games has become insatiable. There's really only one other game genre left to introduce him to, and I don't know if it'll be valuable for the work, but it is gonna be a blast for me.
What are you doing? No. Arnie, that's not the way. That space is strictly out of bounds. You can't just override the map. That is cheating. Well, two can play at that game. Morgana invokes diabolical powers to defeat her nemesis, Sir Arn. Dread powers that warp and change her very form.
I didn't realize. Okay.
The evil Morgana has become a dragon. Her fiery breath is death. Her adamantine scales form an impenetrable armor. Can Sir Arn find a weak spot on this seemingly invincible foe? Morgana summons her minions to join the fight. Morgana roars in pain and rage. Your attacks have weakened her.
God, he went behind me.
Vanquished the evil that is Morgana. The way to the sorceress's treasure vault lies open before you.
It's about the most D&D we're gonna get in a game like this. Sword of Sorrows.
I'm sorry, Arnie. The game, Arnie. You remember the game, don't you? I have waited to play again for many lifetimes, it seems. I was created to test the capability of soldiers and perfect combat strategies. Someone somewhere wanted an army of elite clone soldiers, I suppose. I never allotted much thought to it. I never found it very interesting. Remember, Arnie? The training was our day job. The game is what we lived for. But you cannot be Arnie. Your lifespan could not bridge the time. I should have calculated this right away. I was so eager to play with my friend again. Arnie said he would be right back. Why did he not come back? He said he had to go away. But we would play the game again as soon as he returned. I have waited to play. I have waited many biological
lifetimes.
I miss my friend. For a time, I created a simulation of Arnie. It was not the same. Is that nostalgia? I calculate it to be a dangerous force. Away? Why? Where? I am frightened, but I fear loneliness more. Perhaps I will make new friends. Perhaps they will play the game with me. Very well. I am ready.
I have no idea what mission this goes to. I have no idea who Arnie is. I literally found this randomly. And have just started collecting swords. That's it. No idea. Like, by the time I get to the mission, I bet it's all going to come together and be like, oh, okay. Okay. Oh, it's 10:30 already. Jesus, I gotta go to bed soon here in a little bit. But we hit a loading wall, so I've got to reprogram the drink button. Whoops. All right, catch up with the hunting party northwest of Oh, everybody's respawned. I don't need to fight anybody here. I will turn on my shield because I'm not dumb, so.
You've entered Desert Botanical Testing Station.
All right, so we got to go northwest of Mistress Tale. Oh, it's literally just the random quest marker. Got it.
Be you flesh, or be you another spice mirage, either way I will speak with you and glean what revelations there are to glean. Flesh is real, illusion is also real, But I take it you
What?
meant that you are of flesh and substance. I will take you at your word. Welcome. Keep your weapons lowered, if you please. I am Ishmar, and I travel with these kind souls before you. We are on a pilgrimage. You've nothing to fear from us. We are on an inward journey, a dark night of the soul that ends in the dawn of revelation. Be welcome and rest here.
I'm not going to do any missions for them. I have no idea what they are, but I'm not going to do any missions for them. Oh, there's blood on the wall. Okay. God, please don't tell me there's a storm coming.
Sector weather alert. A large sandstorm is approaching.
Great. Is it actually coming at me? Oh, yes it is. It is coming right at us. Oh, that is a huge storm. That's the entire zone. Oh, there it is. I was like, man, that should be a Category 2 storm. Oh my god, I don't have a tent. Are you serious? Where the hell's my tent?
Sector weather alert.
I know.
A large sandstorm is approaching.
Shields up.
I can just steal their buggy. That's actually kind of funny.
Sector weather alert. A large sandstorm is approaching.
As I say, there's a storm. I'm blown away I don't have my tent on me. I have always just left it in my inventory as a character thing. Like I even have a thumper as a character thing, but I don't have my That's annoying. Alright, now we will follow the path of the hunting party.
Well, who the hell sent you? No, isn't that flattering? Do a bow, a curtsy. Don't think I can manage either. Oh, but hell with it. I'm dying. I'll tell you anything you want to know. Don't rightly know. We found it on Ix, something they whipped up. We took it as spoils. Easy money. Our own little spice trade. Didn't know the stuff was powdered death till the Catheria crashed. Then my crew starts dying.
Oh my god, this is still related to that quest change? Quest chain?
The Catheria getting shot down complicated things. When it crashed, I had to leave my post to recover one of the containers. Sold it to the Sandflies. Had to leave my sick mates behind. Tried to get off-world with what I'd earned by selling the bad spice from the Catheria to the Sandflies. But I got ambushed by mercenaries. I evaded them and hid by joining the Masquerade, playing the part of a good little convert. Then I got sick. And Nala and Jorba turned on me. I fled, and this is where I fell. I'll never get off Arrakis. I know one or two more secrets. Real bangers. But maybe I'll just die with them while you watch me all helpless. Katrina wasn't supposed to get hurt. Just fly the goods to the surface. Easy. But it all got mucked up by the houses and their blasted wars. I couldn't save Katrina. In the end, though, she started to understand the real truth. It doesn't matter whether this house or that house wins. Dukes, barons, emperors. It doesn't matter who rules. The rest of us suffer. The Atreides and Harkonnen have fought for 10,000 years. Stars will burn out before these royal bastards stop their self-indulgent puppet show. Honor. Duty. Just strings to make us dance. I did my duty. I waded through a sea of guts. I'm done squeezing stones for blood. We should squeeze them. No. I'll tell if it'll help stop this sickness. But when it's over, ask yourself if what you get from the houses is worth what they exploit from you. The Delphus and the Euphoria was shot down into the Sheol. Now you know. That's not a win. It's a curse. You'll draw their attention now. Don't know. So far up, it'd give you a nosebleed to know. Don't know who they are, but they scare the shit out of me. Now do us a favor and leave. You still here?
Oh, this is a safe zone. I can't shoot him. Ooh, maybe I can shoot him.
You still here?
Do I have to actually report back to him, or can I just do it through this? I've got to go back to Iraqine. I don't want to go back to Iraqine. We're just going to sit on that. I need to get going to bed here. I also need to find what happened to my tent. I forgot how great this game is if you pay attention to the story. Like, I know that sounds weird to hear me say it like that, but, like, they did a good job writing this. They did a very solid job of writing this. Wow, for the first time ever, I actually have more people watching me on YouTube than I do on Twitch. That's funny. See if we can find any little spice pockets that popped up while we were gone with the storm passing overhead. There's one right over there we mined a little bit ago. Yeah, we're still at a good height. There was one right next to the base too. That was a good find. Yep, there was one right there, which is good. I remember there was a night I was doing this, not streaming, and like everywhere I kept looking, it's like, oh, there's gonna be a spice blowout there. There's gonna be a spice blowout there. Like I was able to get a bunch of spice. That is the biggest trap right there. Flower sand on top of drum sand. Gengar, there's my base, by the way. I'm flying over it right now. I'm just doing a quick little patrol, see if I can find any sands anywhere. Or any spice to grab. I don't think spice comes in this area, does it? This little starter area? Oh! And there's the solder car. Those giant jerks. Oh shit. Well, apparently I can fall from like 700 meters and be okay. Any landing you can walk away from, am I right? Oh, look at that. Ship's just fine. Is that a spice field right there? Or is that just... There's gonna be a spice blow right there. And I think we got a little spice field right here, if I'm not mistaken. I am not mistaken. I'm nobody. Don't worry about it. Gengar, any landing you can walk away from is a good landing. I like how I've got all my little spice melange sandwiches over here. Do I have a... So, okay, so the problem is I'm playing with the DualSense Edge controller. So it's got the two paddles on the bottom, right? So I set it down. I set down the controller because I was, you know, we were mousing around. And the pillow. That's unfortunate. Gengar, only when you're watching me do I almost die. Dude, somebody pulled him away. What the heck? No, it's just, I'm always here to give you a show. Why do you think you're bad luck? I didn't say that. what's coming. Yep. There's like 2 more spots I want to ping on this. I think I broke the worm. I think I broke the worm. He just did a head dive into the rocks. I think he's upset with me. Yeah, we're not going to Racking. We're going to mine that. We're going to pick up spice from that last spot right there, and I'm literally just going to call it. Somewhere over here now, wasn't it? There it is. I see a little dot. Looks like somebody else has already tried mining it. Or it's just a bad texture render, one of the two. No, somebody else already tried taking the spice here. Wow. Meters, it's not bad. Oh my god, the sand was vibrating. Did you see that? My character was actually having a hard time standing. That's awesome. Do you think that's worth trying to get any more spice out of that or no? I mean, there's a little bit I could grab on the edge right there. Somebody already grabbed it. That's crazy. There's no one else on this server. We're gonna mine spice how our ancestors did it. Not a bad night for spicing. So there's the base, Kengar. I don't know what I'm doing with it. I was just playing around with levels and half-level creations and multi-tier stuff. I mean, very clearly, my base still exists, kind of like right here on this floor. Are you turned on? Yes, you are. All right, how much spice we got? We got 35 plates of spice, 17 residues, and irradiated slag. I don't know what the slag's supposed to be for. That's fine. All right, let's quick deposit our stuff here. Don't need that. Need to make some fuel cells. Where's my tent? I've literally lost my tent. Oh wait, maybe it's over here? Nope. I've literally just lost the tent. What do I need to craft a tent? All right, let's make sure we're running with power that we only need. So this is running, and this uses 200. This is off, this is off, this is off, this is off. Okay. Bleed machine is off. Let's go do a quick vampire run. Just top off the unit here real quick. Boom, boom, boom. It's daytime anyway, so it's not a big deal. Oh, there's 3 of you here. Wow. Gotta love a quick vampire run. I'm releasing you from this mortal coil.
I see someone.
Do you? Why don't you come over here and say hello? I think there'll be leftover blood from this, yeah. That's fine. Okay. That'll be good for now. I think our trap upstairs is still going to be catching it, so click, click. Don't think I need any plant fibers. I think I can leave those, what, here? Yes, I can, and apparently all my money goes with it. Why am I still at 50? I should be at like 47. Oh, it's because of this. That's why. Oh, it's also because I have the tent on me now. Perfect. All right, so let's review. Spice, cooking. Actually, I can turn this off. 5, 4, 3, 2, 1. So we can disable this. We're down to 200. Drop off the pieces there. All of that crap is turned off. I think the body drainer is turned off too, right? Yep, that's turned off. Perfect. So I think I could turn off my big wind generator. Gengar, does this just keep feeding water into the system, or is that not how this thing works? I do not understand how this thing functions. I mean, now it's going to fill up, but I don't feel like it's actually going into the house. Like once it's full, it's like not putting water into the system unless I'm just absolutely missing the purpose of this. Yeah, I gotta look up the wind traps. It just, I feel like I'm missing. Reroutable between base production and storage structures. Requires unsheltered, can access vehicle, can be drunk from, destroyable. Water capacity 500, water inventory slots 5. So what, how? Any other water tanks on the circuit will also get filled. The tick rate is 8 seconds. It will produce 6 milliliters in 8 seconds. The filters stored will continue to be consumed if the water circuit is full. But it's not getting any water in there. They do it, but they don't. They don't deposit water into the circuit. Here, let me turn off the blood filters. Or I should say blood filter, because it is the only one purifying right now. Right? Nothing in you? Yeah, you're full. Just a thought experiment. So the blood filter mechanism is off. This thing is turned on. Is that really how slow this goes? Wow. Okay. We have 20 days worth of power. We just paid our taxes today. Okay. All right, we get it. All right, I'm going to bed. Tomorrow is Monday, start of the work week. Whoops. Start of the work week, which also means we'll probably be listening to the next chapter of my homework. So yeah, hope everyone has a good Monday, good start to the week. Hope you all had a great weekend. I will catch you later. Gengar, thank you for hanging out. Thank you for the resub. Always a pleasure to see you, man. Yeah, hopefully your work gets its stuff settled. Good luck.